Good morning again. Hello. I'd like to call this meeting to order. The time is 9:02. Today is Wednesday, June 24, 2026. This is the first day of a two-day meeting of the Physical Therapy Board of California. Today we are meeting in Department of Consumer Affairs, 2005 Evergreen Street, Hearing Room, Sacramento, California, 95815. This is an official business meeting of the Physical Therapy Board. The board's role remains to maintain consumer protection and consult with local and state authorities on laws and regs pertaining to the physical therapy industry. We will take public comment on specific agenda items, and at the end of the meeting, there will be a comment section for items not on the agenda. Public comment must be specific to the agenda item that is being discussed. If you would like to make a comment during a specific agenda item that is not related to that topic, you will be directed to hold your comments until we reach that appropriate agenda item. All comments that do not directly relate to an item on the agenda should be held until the agenda item for items not on the agenda. The board follows the Open Meeting Act, so while we accept and appreciate the public's comments, we cannot respond to those comments. This meeting is being recorded and the minutes of the meeting will be prepared. Can we please have a roll call?
Karen Brandon,
Here.
Dale Armstrong,
Here.
Tala Kaloff. Tala Kaloff is absent. Tanya McMillian,
Here.
Samuel Q.
Here.
All members are present with the exception of Tala Kaloff, and the board has a quorum.
Great, thank you so much. I'd like to ask Dr. Armstrong to read the board's mission statement.
Thank you, Dr. Brandon. The mission of the Physical Therapy Board of California is to protect the people of California by the effective administration of the Physical Therapy Practice Act.
Thank you. So before heading straight away to agenda item number 4, with our special order of business, as board president, I would like to welcome everyone here today, board members, staff, and stakeholders, especially any members of the public. We will be starting at special order of business, petitions for reinstatement. We are joined today by the Honorable Judge Aspinwall, sorry about that. And he will take over with our first case.
Okay, good morning. I'm going to call to order. We are on the record in the matter of the petition for reinstatement brought by James Ward Jr., physical therapist. This is case number 720-2025-005365 and Office of Administrative Hearings number 2026-040965. My name is Timothy Aspinwall. I am an administrative law judge at the Office of Administrative Hearings, and I've been assigned to preside over these matters. The record should reflect that we do have a quorum. And may I please have the appearance from the Attorney General's office?
Good morning, Your Honor. John Gatschet, G-A-T-S-C-H-E-T, Deputy Attorney General, appearing on behalf of the Attorney General's office and the public in this matter.
And the petitioner, Mr. Ward, is present and representing himself. And Mr. Ward, I talked to you along with Mr. Gatschet briefly prior to these proceedings, and just want to reemphasize a couple of points that the focus of this hearing is on rehabilitation. It's not a time to relitigate prior discipline. Procedurally, we will move forward with Mr. Gatschet, the Deputy Attorney General, presenting a summary of the case to the board, including your petition packet, which I will mark in evidence. You will then have an opportunity to testify under oath. And I take it you do not have any witnesses you wish to call, correct?
No, I don't.
And when we conclude with that presentation, you'll have the opportunity to present your side of the case and testify. First, the Deputy Attorney General may ask you some questions, and then the board members may ask you some questions. Following that the board will go into a closed session to deliberate, and a written decision will issue there. Any questions? No. Okay. Mr. Gatchett, please. Oh, yes, thank you. Thank you. Mr. Gatchett?
Thank you, Your Honor. So we'll just do a brief opening kind of overlay for the board members. Petitioner James Ward first received licensure as a physical therapist in April of 1985. His license history is as follows. He was publicly reproved. His license was publicly reproved in case 1D-2010-69787 on June 20th, 2014 for conduct occurring in 2007 and 2008. The public approval was related to the unsupervision of two unlicensed physical therapy aides who were operating without his direct supervision, and also petitioner signing off on their charts where the patients were only seen by aides as if he were supervising them. Okay, so we have that public approval as part of his license history. At the time that that case was going on, unknowing to the board, petitioner was working for a company called Rise Wellness Center. Despite knowing, especially because of the public approval case that was pending, that he could only supervise one aide at a time and that he needed two directly supervised aides, petitioner entered into a conspiracy with the owner of Rise Wellness Center to allow aides to see patients and bill insurance company under petitioner's provider number. He admitted he signed off on notes when work was done by aides as if he had performed the work. In total, between 2011 and 2016, petitioner's provider number was billed for almost $5 million for work that petitioner did not provide. In addition to the billing fraud, petitioner also made false statements to the IRS, and in 2012 and 2013 owed an additional $15,000 and $22,000 respectively. He was federally indicted in case number 18 CR 3058-BAS, and in 2021 he pled guilty to 2 felony counts, conspiracy and tax evasion. He was ordered to serve 12 months and a day in prison. This board revoked his license in case 720-2018-0001734 on May 27th, 2022, pursuant to a stipulated revocation. On June 23rd, 2025, petitioner applied for reinstatement of his license. He is seeking an unrestricted and unencumbered physical therapy license with the board. I would note to the board that it is the petitioner's burden to prove by clear and convincing evidence that he is entitled to the reinstatement of his license. My role is to question the petitioner and serve on behalf of the public in this proceeding. The board may examine petitioner's rehabilitative efforts since that time. Rehabilitation can include acknowledgement of what he did, the restitution paid to both the board and the criminal courts, the status of those, his letters of reference, any training and education he has done in the time since he lost his license. And the board, in granting this petition, may grant the petition, the board may reject the petition, or the board may grant the petition and place the petitioner's license on probation if the board were to see fit that probation is appropriate in this case. I will state at the outset, the Attorney General's office opposes this petition. And so with that, Your Honor, if you'd like me to move into the evidence, I can do that at this time.
Yes, please.
All right, we have a number of exhibits. Exhibit 1 is the petition. It's 3 pages, redacted. We'd ask that it be admitted for all purposes.
Let me just ask you in advance, Mr. Ward, are you going to have any objections to any of the documents being admitted in evidence?
No.
So 1 is in for all purposes.
All right, and Exhibit 2 is the request for hearing with OAH. asked to be admitted for jurisdiction purposes.
2 is in for jurisdictional purposes.
Exhibit 3 is the board notice of hearing that was provided to petitioner for today's date. Petitioner is here. We'd ask that Exhibit 3 be admitted for jurisdictional purposes.
3 is in for jurisdictional purposes.
Exhibit 4 is the Department of Justice notice of hearing. We'd ask that be admitted for jurisdictional purposes.
4 is in for jurisdictional purposes.
Exhibit 5 are the certified prior decision and order in case 720-2018-001734 and case 1D-2010-69787. We'd ask these be admitted for all purposes.
5 is in for all purposes.
Exhibit 6 is the Breeze license status of Mr. Ward, showing that his license remained in revoked status as the time of that Breeze printout. We'd ask they be admitted for all purposes.
6 is in for all purposes.
Exhibit 7 is the petitioner's narrative statement that was attached to his petition. Those are pages 49 and 50. Ask that it be admitted for all purposes.
7 is in for all purposes.
Exhibit 8 is the order granting early termination of supervised release in petitioner's criminal case. We'd ask that be admitted for all purposes.
8 is in for all purposes.
Exhibit 9 consists of 2 letters, one from a Dr. Suraj Kushwaha and the other from a Dr. Anthony Tam, 2 physical therapists who have written letters in support of this petition. We ask they be admitted for all purposes.
9 is in for all purposes.
Exhibit 10 is the certificates of completion for some training that petitioner performed. We'd ask those be admitted for all purposes.
10 is in for all purposes.
Exhibit 11 is the probation monitor report, page 56 to 70. We'd ask it be admitted for all purposes.
11 is in for all purposes.
Exhibit 12 is a letter to petitioner requesting discovery in this case. We'd ask it be admitted for jurisdictional purposes.
12 is in for jurisdictional purposes.
Exhibit 13 is Title 16 CCR 1399.21, which is the code of regulation for the board in reviewing a petition for reinstatement and what the board can look at. In terms of that petition, we'd ask it be admitted under official notice.
Official notice is taken.
Exhibit 14 is Flanzer versus Board of Dental Examiners, setting forth that a petition for reinstatement, the burden is clear and convincing evidence on the petitioner. We'd ask the board take official notice.
Official notice is taken of 14.
And then in the supplemental packet, and I do thank the petitioner for providing the information so that we could provide it here for the board today. Exhibit 15 is additional certificates of completion for continuing education. Ask they be admitted for all purposes.
15 is in for all purposes.
Exhibit 16 is a letter of support from a former employer. We'd ask that it be admitted for all purposes.
16 is in for all purposes.
Exhibit 17 is current employment information from the petitioner about what his current work status is. We'd ask that be admitted for all purposes.
17 is in for all purposes.
Exhibit 18 is a letter from a counselor the petitioner provided. Ask they be admitted for all purposes.
18 is in for all purposes.
And then finally, Exhibit 19 was a letter to a judge in petitioner's criminal case from a few years ago. We'd ask they be admitted for all purposes.
19 is in for all purposes.
And that's the exhibits that we have in this case.
You have any person you wish to have make a statement or testify?
I do have the probation monitor, Mr. Martin, here that I have some just brief questions for. We can do that after the respondent testifies or before the respondent testifies. It is not respondent, petitioner. It is petitioner's burden. So in terms of burden of proof, he would typically go first at this point.
Is that your preference?
That would be my preference.
Okay, Mr. Ward, I'm going to ask that you stand and I will swear you in. Raise your right. You solemnly swear. Affirm. Okay, Mr. Ward, the floor is yours. You tell the board what you wish to say.
Okay. Good morning to the PT board and Judge Aspinwall. and staff. And um, I want you to thank you basically for allowing me to be here today. I just wanted to let everybody know that physical therapy is still very important to me. It's been pretty much all I've wanted to do since being a junior in high school way back in 1973, 74. I acknowledge that I've made some mistakes within the practice of physical therapy and mistakes that have caused disciplinary action to be taken against me. Uh, Unfortunately, with some of the previous mistakes that I made, I wasn't strong enough in a kind of a high-paced work environment, and my lack of action and response at that time led to some financial abuse by the company. However, I do want you to know overall that my drive to be a good physical therapist is very strong, and I still feel like I can provide good, strong patient care. And I'm a much stronger person today than I was 10 years ago when all this transpired. I will never let the events that happened in the past happen again. And if given the chance for reinstatement, I plan to practice in a safe, competent, and ethical manner moving forward. Rehabilitation wise, I think I've learned from the experience. It's been 5 years now. And the main thing I've learned is that um, especially within work environments, you have to confront issues head on and not kind of wait and hope that things get better. Um, I, I plan to continue as far as part of my rehabilitation. I plan to continuing education courses to help me with just staying up to date with not only the rules and regulations of the Physical Therapy State Practice Act here in California, but also the rules and regulations for the different insurance carriers as well. And also we'll continue to take continuing education courses to stay up to date with the practice of physical therapy in general and to maintain my clinical competency. Secondly, I had to take sort of an introspective look at my past behaviors and responsibilities and look to develop a framework for handling stressful situations at work and not to ignore pending problems. I wanted to take the initiative towards this self-improvement. So I'm currently receiving ongoing counseling for the purpose of stress management, improved decision-making, and framing techniques for stressful situations. This training will allow me to handle situations that arise, whether it's an ethical issue or a personal issue, more directly and effectively. No longer will I shy away from conflict, whether it's personal or professional, and this will help me moving forward. The counseling will also help me to manage my actions as a physical therapist if given the opportunity to move forward, especially in any high-risk situation where problems need to be identified and addressed quickly without hesitating and hoping just that the situation gets better on its own. And this will allow me to practice in a safe and ethical manner and set professional boundaries to ensure that my past conduct will not happen again. Just as a little bit of history, the issues that Mr. Gachette brought up, I handled certain situations differently back in 2004, especially 2014 through 2016. That's the main time period where I actually used the aids. From 2009 to the beginning of 2014, I was a sole provider of physical therapy at Rise Wellness Center. So that's just a little bit different in terms of just the timeline of when the aids actually came on to work. And sure, it was right at the same time that I was resolving the previous decision and order. But we actually started off on a positive note in terms of the aides there were properly trained, tested, and given direct patient tasks to do, and also non-direct patient task to perform as well. And we had everything pretty much in order, but um, the owner that I worked for at the time of the clinic had a different approach to in terms of what he wanted the aides to do. They were actually his employees; they weren't my employees. So um, it created sort of a toxic work environment in terms of the owner not wanting um, to abide by what the actual rule was, and I did address that with him directly, but it was a lot of back and forth, and over time, I mean, I look back at it now, and I should have been a stronger person at the time, and actually should have been a situation where I just walked out of. I mean, just it was that toxic of a work environment. But I really enjoyed the practice that we were in. We were doing actually, very good care. We had good outcomes in terms of patients and improvement. And I really wanted the situation to work, and I think that's why I didn't just walk away from the situation at the time, unfortunately. Uh, but like I said, I have a pretty good rehabilitation support group now. I have my counselor, psychological counselor. I have some former employers that are helping me through this process, and even my current employer too is supportive in terms of hopefully trying to get my physical therapist license reinstated. And I have a lot of family and friends that are medical professionals that are um, supporting me through this process as well. So, as far as any type of future plans, if my license is reinstated, um, uh, I I would plan to practice in more of a home health setting. That's where most of my experience is. Uh, Prior to my discipline, I worked from 2017 through 2021, specifically in home health services as a sole provider, uh, working for, at that time, a company called Camellia Home Health. And we provided physical therapy, nursing, and occupational therapy, primarily for the developmentally disabled population in San Diego. Um, and my job was basically we worked as a team with the nurse, the OT, PT, and sometimes the speech and language pathologist as well, uh, in terms of helping this special needs population that in San Diego County, it's an underserved population. Like we had really good outcomes in terms of preventing uh, rehospitalizations, and when the clients were if they had an acute admission and they were discharged to home therapy, we had a really good rate in terms of them improving and getting them back to baseline. And like I said, not them not having to go back to the hospital. Uh, I have a letter in the packet from the home health company. Uh, uh, they would be able to provide any type of stipulated employment that the board would deem appropriate if the license is uh, reinstated. Um, like I said, I worked for there for 5 years where I didn't use not even a licensed assistant. I did the evaluations and followed the clients myself. And that's kind of where my focus would be if my license is reinstated, um, seeing my own patients and following them. That type. And as far as my current employment, I work after my disciplinary punishment. I felt it was important to get back into the work environment. Um, so I took an entry level position for a home health company that I worked for before. It was primarily admin support. Um, I did filing. I did uh, filling of orders for DME equipment, and also just supplies. And I helped help them with some aspects of scheduling and general office work, answering the phone, that type of thing. Um, I did that for 2 years after my disciplinary punishment, and but was recently laid off about a year and a year and 2 months ago, primarily because they merged with a different company, and the company that they merged with already had office support personnel. But they did offer employment if I'm able to get my license back and come back as an actual clinician. My current position, I work for a company called Aloha Senior Home Care, and we provide non-medical caregivers for seniors in San Diego. Um, the position I'm in right now is called a client care coordinator position. Basically, I do the orientations for they're primarily healthcare aides and some CNA like positions where they the home care aides basically work with clients in San Diego with elderly adults that need either personal or companion care in the home. So my current job is working with that company. I do their orientations and also with the owner of the company, I do some of the site visits with her as well. She has also offered an expanded role if I get my license back in terms of more physical therapy appropriate intervention as far as training of the caregivers, whether it be safety, body mechanics, that type of thing, and also providing more extensive in-home assessments for clients as well. So, um, that's kind of where I'm at with everything right now. Thank you.
Thank you. Mr. Gatchett, do you have questions?
All right, Mr. Ward, maybe you can help me just with some clarification. In your testimony, you stated at Rise Healthcare there were no real issues from 2009 to 2014. Is that your testimony?
Well, we didn't, from 2009 to the beginning of 2014, I just saw the clients myself. I didn't utilize an aide at that.
Okay. And I was looking at the accusation that led to discipline and that you admitted. If you could look at page 31 in the packet for me.
Can you reference what exhibit that is?
Exhibit 5, Your Honor.
Yes.
And then page 31 of that exhibit. There should be a Bates stamp on the bottom right-hand corner. You have the 2 booklets I gave you? Tell you what, hand me the booklet and I'll go right to the paper. All right, let the record reflect he's at Bates stamp page 31 now. If you could look at paragraph 14 on that page, in that document, it says between July 2011 and December of 2016, Rise fraudulently billed Medicare and TRICARE under your provider number for approximately $4.9 million for services you did not provide or were provided by an unlicensed individual without direct supervision. Do you deny that that occurred, or how would you explain that to your testimony that the aid issue didn't really occur from 2014 to 2016?
No, the aid issue occurred in 2014, but it was like middle of 2000.
Was there problematic conduct at Rise before 2014?
There was, in terms of the owner, basically it was a multidisciplinary medical center. So they provided physical therapy, medical services, chiropractic, and acupuncture, and massage therapy. The actual owner at the time billed out some of the services provided by the acupuncturist and the chiropractor as physical therapy, and the massage therapist as well.
Okay. Do you agree that your provider number at that time, and by extension, your license, was being used to defraud before 2014?
Yeah, in some aspects, yeah.
Okay. And then I guess the next question I have is if you go further down that page, paragraph 16, we have the allegations involving what was charged. You agree that you were charged with conspiracy to commit fraud from 2009 to 2016 for what was going on at Rise?
Yeah.
Okay. And you also agree with me that you also had tax issues, that you had underpayment with your because of overclaiming, and that's set forth in paragraph 15 on this same page in 2012 and 2013, which also resulted in some felony charges related to felony tax evasion.
Yes. With the tax issue, it primarily had to do with I had a former private practice, which I stopped in 2007. And the company did an asset purchase, and they took the lease assumption at that point. What happened was basically the company that took over didn't live up to the lease, basically. So the management company later on came after me because I was original signer on that. So I actually had to give a deposition. I forget what year it was, but it was probably closer to right around 2012, 13 at the time that they came after me for the back rent that was never paid by the company that took over the lease assumption. So it was the reason that I kept those expenses on that 2012 and 13 as far as the rent is because I wasn't sure what the outcome at that time was going to be in terms of if I was going to be responsible for the lease payments for those years that they did pay. I ended up not having to pay it later on, and actually, I mean, it's my fault because we had with the tax preparer that I was using at the time, we had planned to go back and do it and amend those years' tax returns, but it's my fault. Yeah, I never got back to it.
And it was such, and I hate to stop you there, Mr. Ward, but it was such your fault that you were charged with a felony and pled guilty to a felony tax evasion. Okay. If we could just go to page, in your binder there, page 41, and this is still in Exhibit 5. And you'll see the bottom bait stamp. It's really small, but on the bottom right-hand corner. Wasn't my
45?
41. Wasn't my goal to make it an eye test, but all right. I talked about this in the opening, and you referenced it in your testimony. This was the accusation in case 1D-2010-69787. I wanted to know, when did you first see this document?
This particular one I had attorney.
Okay. Now, the filed stamp is March 4th of 2013. Do you have any reason to believe you didn't see the document close in time, within a few months of that document being filed?
No.
Okay. Probably saw it. Okay. And at the time you received this document, you were working for Rise. Is that correct? And did you have a chance to read the document and read the accusation? Okay. And you read those allegations with an attorney? Okay. And went through and understood that the board at that time was concerned that you had been in 2007 and 2008 signing off on charts for work that was not done by you, that was done by unsupervised aides. Was that a fair understanding of what you believe the allegations were?
Yes. Yes, for the most part. But if I remember correctly, we were able. Yes, I'll say yeah.
Okay.
That was-
And, and then part of, what you're here before the board here is that similar allegations and similar issues, but on a, let's say, much bigger and, more criminal scale, occurred at Rise starting in 2014. I think that was your own testimony. So you were on notice from this accusation, weren't you, that kind of that conduct was problematic? So can you just tell us why you didn't stop what was going on at Rise?
Initially, so when we initially started to use the aides at Rise, it was a good intention to get them up to speed, educated. I was in charge of the schedule. So we did have two aides, and I could basically had them divided up into two shifts and I had complete control over that initially. The aides they were interviewed, they were trained, they were tested on what their performance. They knew that only I would be the one supervising them, and nobody else in the clinic supervised. So they were educated and everything. And we initially started off very well. It was just sort of after about, I want to say 3 months into that, the owner took the scheduling privileges away from me, and meaning that it was a computer software where I usually did the scheduling, and I could organize it so that proper supervision was taking place. When I was removed for that function, and then the owner basically had a staff just schedule the aides on their own, basically, irrelevant of when I was there. Right. I mean, it was an issue, and I did confront the issue with the owner. In retrospect, I probably should have walked away from that situation or run away from it. It was that bad, especially since the proximity of the previous case that required the decision in order. So, I look back on it now, and I probably should have walked away. Like I said, it was a situation I thought that we could resolve over time, that we could get it all straightened out. And like I said, I really enjoyed the work environment, the patients, and the situation there. And I think that's why I hesitated, basically, unfortunately. And then it kind of snowballed from there, because the scheduling got chaotic, the clinic got busy. I tried to keep up as much as I could as far as the supervision aspects of it, but it was just a lot. And unfortunately, it snowballed into, like I said, something very, very massive.
Let me ask you this. How much were you being paid roughly in 2014 and 2015? What was your gross?
I was paid hourly. When I first started there, it was $52 an hour. At that time, I never made more than $55 an hour. I was an hourly employee, not employee, but contractor.
And $55 an hour, but how many hours were you booking?
The hours wise, I worked anywhere from, depending on the day, 8 to 12 hours. They were long.
Okay, and so 5 days a week,
5 days a week.
52 weeks a year. Sometimes 6 days a week. So
Not 8 hours on 6 days a week, but sometimes I had to come in on Saturday.
So would you have an estimate about how much you were grossing then?
I don't have my tax forms in I
Oh.
know that, I saw the number in there. It was like during the period of time, it was like 550 something. I saw, it's in here.
Yeah, I saw in the accusation, and the board can reference back to that as well.
Based on $55 an hour.
Was part of this that you didn't want to quit because you were making pretty good money and didn't have to have a lot of responsibility for it?
No, it was mainly, I thought, number one, I thought we could resolve it over time. And number two, I really enjoyed the work environment and the patients, and like I said, we had really good outcomes in terms of improvement.
I got to say, Mr. Ward, when you say resolve it over time, especially after the board had already brought an accusation against your license for similar discipline, that's an interesting thought to have. Okay. All right. I want to talk about what you told the physical therapists that provided letters to you. How specific were you about the allegations involving the discipline that occurred with your license when you went to talk to the two letter writers that are before the board here?
I just explained to them sort of what happened in terms of the indictment and charges and punishment.
So you mentioned there was a criminal case?
Yes.
Okay. And when you talked to them, did you blame the owner of Rise, or did you state that, you were at fault, or what, how did you do that?
No, I stated both. I think it's both. Also, the owner,
And just kind of ballpark some percentages here. For the conduct that occurred at Rise, and let's talk about the conduct from 2014 to 2016, if we were going to put a percentage at that in terms of the conduct that involved the physical therapy aids and the fraud that occurred, would it be like 50% fault that you kind of look at? Would you say it's 75% his fault, 25% your fault? What do you think as you look back?
say, because there was some billing done without my approval or knowledge. So I would say we had to put a percentage on the 70, 30,
70-30 who?
70% on the owner.
Okay. And I think when you said the part of this reason you're putting in your mind 70% of the fault on the owner is because I think you mentioned in your narrative statement, you learned that he had a file stamp that in addition to the aides that were not supervised by you and the charts were being signed off, he was also independently stamping charts. Okay. But you would agree with me that at any point, if you had just quit, it would have stopped it.
Absolutely.
Okay.
I look back at it now and I can't even think.
You wrote in your letter that you stated the emphasis of knowing the importance of payer rules and regulations when you talk to other physical therapists. What do you tell other physical therapists when you meet them about the importance of payer rules and regulations?
That may vary. I mean, I think you have to adopt the most restrictive policy, whether it's with the payer or, I mean, you definitely have to follow the Physical Therapy State Practice Act. But sometimes in terms of supervision, at that time, it wasn't consistent. Some payers would allow either a licensed assistant or an aide to help, other payers not. And so I think it's important that therapists know not only what their state practice act says, but also what the rules and regulations are of those insurance providers as well.
Now, I know that I believe that it was a doctor, was it a medical doctor that owned the Rise Healthcare? Or was he a hospital? Chiropractor, okay. So it was a licensed chiropractor that owned Rise Healthcare.
He had some medical doctors that were partners. I'm not sure what percentages, but yeah,
You were never a part owner of Rise Healthcare
never.
or Rise Wellness. Let me ask you this. In a healthcare setting where a provider's MPI number is being used for billing, whose responsibility it is to make sure that the billing is not fraudulent under that MPI number?
That was my responsibility.
Okay.
Yeah.
So you agree that the captain of the ship on any billing is the person's MPI number, regardless of what anybody else is doing? Okay.
And I should have, like I said, in retrospect, looking back at it, especially because he had actually billing meetings, which the clinicians were not allowed to attend. And that should have been a red flag at that time. Something.
Tell me about that. So when did you learn about that?
Um,
When did you first learn about that?
it was probably right around 2000. It was later, like right around, probably, I want to say 2015, 16.
So a year after you lost access to the scheduling, based on your testimony, about a year after that, you learned that the owner was billing for meetings that for insurance companies, that meetings that you knew were not even.
No, I mean, he was having meetings with his billing staff
Ah.
regarding, what was being billed, and clinicians were not allowed to attend that meeting. So I wasn't aware of the scale.
Okay, so you'd lost access for the scheduling, and then you become aware that there's these meetings going on with billing staff, which would be using your MPI number, and you weren't allowed to go to those meetings. And yet you continue to work there for another year and a half?
It was right towards the end of 2016, I started to phase out.
So it was another year? Okay. And we would be fair to agree that during that time, when you learned those meetings on billing were occurring that you weren't part of, the other case had now been pending for almost 2 years at that point.
Yeah.
Okay. All right. What is the status of restitution in the federal case? Have you paid it completely, or are you still ongoing payment?
Payment I pay, since my disciplinary action, I paid about 30,000 into it so far.
Okay, let's talk.
And it's, I have a portion that comes out of a retirement payment that goes directly to restitution, and plus from my current employment, I send a payment.
Just for the board, so it's in the record, what was the total restitution award that was owed in the federal criminal case?
I think it was 2.9, say 2.975, I want to say million.
So there was a restitution award of $2.9 million and change, call it 2.9. And you've paid approximately, you said $30,000?
Since, yeah,
And then roughly how much per month are you paying towards that $2.9 million?
right now I pay about $1,000. That would change depending on employment. They base it on your income coming in. My income has to be assessed each year to determine what that secondary.
Sure. And so it's just clear in the record. So at this point, you still owe on the federal criminal case restitution approximately $2.8 million and change.
Yeah.
Okay. Is it also growing just by interest, or do you know?
I think so.
In terms of restitution to the board, have you paid all the restitution that was owed to the board?
I believe I have.
In your letter to the court, and I think that was page 106, and that was in the supplemental booklet. So we'll have to open up the supplemental booklet, and it's Exhibit 19.
A letter to,
The judge dated August 10th, 2021.
yes.
On the bottom paragraph, there was a sentence, and I'll read it here. The scheduling staff started just giving the physical therapy aides a full schedule as a result of orders from Dr. Candelario. Dr. Candelario is this chiropractor. Okay. And then it says, I resisted this vigorously and tried to get them to reschedule or cancel patient visits. Can you tell me what you meant when you wrote to the judge that you resisted that process vigorously?
I actually would go physically and go to the scheduler and actually cancel the visits that they had lined up for the aid. Again, I had access to the system, so I could go on, and if I saw something that was not scheduled properly, I could just go on and tell them. I can go on and actually change and cancel those visits myself.
So this time frame is probably what, 2013? Because it's before the 2014 loss of access?
No, we didn't start these aids until 2014, a little bit later.
Okay. So you started with the aid, so it was in that 3-month period, I think was your testimony, that you had access, you could schedule, and then they cut off access. Okay. Resisting vigorously, that did not include just quitting from this job.
Oh, I know, I confronted the billing staff and the owner regarding the inappropriateness of it, that it was improper that they have a full schedule and that everybody just has a full schedule. I said, this is not the right way to do it. And it got a little bit better in terms of them scheduling a little bit, but then they were getting pressure from the owner to schedule everybody a full-time load.
And then you lost your access.
Then they took away the computer access so that I couldn't change it at all.
And so would it be fair to say your vigorous resistance at that point stopped?
Yeah.
Okay. All right. In that letter, you stated that your daughter at that time, and this was back in 2021, was preparing to go to college, but the loss of your license was going to cause financial difficulties. In terms of your petition here, is the reason that you want your license back so you can make more money?
Well, the reason I want my license back is I love the field of physical therapy. I mean, it's all, like I said earlier, it's all I wanted to do since being in high school in 1974. Not having my license over the last 4 or 5 years is just definitely a piece of me that's gone, and I feel it every night. And it's not the time I spent in prison that keeps me up at night. It's the losing my license, and that's what keeps me up at night and tossing and turning. Yeah. I mean, I would say, yeah, definitely. I'd want to be compensated as a therapist once I get my license back, but the percentage is going to be the same whether I'm making, meaning that I have to report that to the government for my restitution. So they're going to take the same percentage. It'll just be percentage on a larger amount.
Are you being paid hourly right now, or are you paid on a salary basis?
Right now, it's on a salary basis.
Would you be able to approximate your hourly wage right now if you were to take your salary and break it out?
I think it's like 20. I want to say it's minimal. I mean, $24 an hour.
Okay. And so you were making 55 at Rise, and that was, 10 years ago. Safe to say that if you were to get your license back, I mean, your expectation is to at least double your salary.
Yeah.
Okay. I want to talk about some of the writers. We have physical therapist Suraj Kushwaha, Dr. Kushwaha, who wrote a letter for you. When did you first meet Dr. Kushwaha?
I met Dr. Kushwa through Camellia Home Health Services. It's the company that I worked for. Met him more on a regular basis right in 2023.
All right. So it's fair to say that Dr. Kushwa, he never knew you as a physical therapist?
No, he just knew from what the owners, he was with the owners and the staffs at Camellia Health. Most of the information he got was probably from them at the time. But yeah, no, while I was actually treating
Yeah, word of mouth. He didn't have any personal knowledge.
personal knowledge,
No personal knowledge of how you are as a provider.
just from the staff.
And then Dr. Kushwa, when you talked to him about writing a letter or when you met him, did you tell him that you had been convicted of a felony and sent to prison? Okay. And did you tell him why?
Yes,
What did you tell him specifically about why you had that conviction?
I was sent because of the issue with healthcare fraud and specifically billing and also on a tax relief.
Tax-related issue is a nice way of saying tax evasion. So did you use the word evasion or no?
No.
Okay, all right. Did you give him the disciplinary documents that are online from the board's website before he wrote his letter?
Yeah, there was kind of an outline on what the board wanted in terms of the letters. So
So he did have the decision? Or he had access to the decision in order if he wanted it? Okay, all right. All right, physical therapist, Dr. Anthony Tam. Dr. Tam, now he knew you, when was the first time he knew you?
2000, I want to say 19.
At that time, you were still a licensed physical therapist.
Right.
Did he ever work with you?
Just in terms of the handoff of when I was leaving the medical center, somebody eventually took over for Dr. Candelario, and I was transitioning into home health, so he was taking my excuse me.
Okay, so
He was taking over the clients that I had there. So we did have a chance to review the clients that were still going to need physical therapy, because he was going to become the therapist of record for that facility going forward.
okay, and then I'm guessing at some point, you went to prison. You probably lost track with Dr. Tam. When was the next time you saw Dr. Tam?
2023. All right. Got out.
When did you approach him to write a letter for the board?
I believe it was about 2 months prior to me actually submitting, 2 or 3 months prior to me submitting the application for reinstatement.
Okay, did you tell Dr. Tam that you were having financial problems and that you needed to get back to work as a physical therapist during that conversation?
No, I didn't really discuss financial issues. I mean, he knew I was working as a office support and that type of stuff.
Prior to Dr. Tam providing a letter to the board, at any point, did you discuss with him that you were having financial issues and that you needed to get back to work?
No, I don't recall.
In terms of working as a physical therapy aide, so an unlicensed aide, at any point between 2022 and 2026, did you work in that capacity?
As an aide,
Yes.
2022 and what?
2022 and 2026. I'm just asking you
No,
tangentially, yes.
No.
All right, now to Mr. Martin, the probation monitor, he did the petition evaluation and investigation. You stated that you were more assertive now, is that correct? So the fraud could not happen again?
Yeah, I feel like I've learned from my mistakes of the past and address issues quickly and be more decisive upfront. I just feel like it's important just not to let things dwell, and especially when it comes to these types of legal issues. So yeah, I would, if the same issues arise nowadays, I would not hesitate to walk out of them. And no matter what the employment situation is, I never really want to go through again what I've been through over 5 years.
Aside from your own assurances, is there anything else the board can rely on if it gives you a free and clear license?
Any what? Say it again?
If the board gives you a free and clear, an unencumbered license to practice physical therapy, aside from your assurances, is there anything else the board can rely on that the public is going to be protected?
Basically, I'm going to stay on top of any type of legal issues and comply with not only the Physical Therapy Practice Act, but like I said, making sure that I understand it from the insurance carrier's point of view as well. I feel like I have more of a framework for addressing issues that might come up in terms of an ethical dilemma.
Right.
I feel like I can address those more quickly and more directly and make a good choice in terms of what to actually do about the situation. Also, and put a plan of action together. And then that plan of action would either be to get it resolved immediately or to leave that situation.
And I'm not advocating for this. I want to be very clear with you. The Attorney General's office is opposed to your petition outright. But if the board were to grant you a license, the board would have the option of issuing you a probationary license. They could impose a term of probation as long as they'd like, I mean, up to potentially 10 years. I just have a question if we went through that. The board does have a number of powers that it has under a probationary license to have oversight. I'm just curious if you'd be willing to follow that oversight. So for example, if the board mandated that you had to have a direct supervision by another physical therapist, would you do that? Okay, if the board mandated that you had a practice monitor, would you do that? If the board mandated you could not practice home health care, would you do that? The board mandated you could not practice in a solo practice, would you do that? And if the board mandated you could not be self-employed, would you do that? If the board mandated you could not perform direct billing, would you do that? And if the board mandated you could not do supervision of physical therapy assistants, would you comply with that? And if the board mandated you could not do supervision of physical therapy aides, would you comply with that? Okay, so to be clear, whatever conditions the board would impose, you would follow. And understand that any licensure you get is at this point a gift. Okay. I have no further questions, this witness. Thank you.
Thank you. Dr. Brandon, do you have questions?
Thank you. I do. Thank you both for your presentations on this matter. Mr. Ward, I'd just like to commend you. I do recognize the challenges of trying to gain lawful employment after what you've been through and specifically after being in prison. And I know that that's also an extension of the people that chose to have you in employment after going to prison. So I think that's definitely a valuable opportunity that you were given for sure. I think that maybe the first question I have is about, you mentioned that you needed to be a stronger person. Can you expand on what that means, stronger person?
A stronger person in terms of of how I react to different situations that that it could be an ethical situation at work or even personal situations. Um, I needed to be a stronger person in terms of how I address it, in terms of addressing it immediately, trying to um, get the situation resolved, and initiating a plan of action. Whereas before, I think I was the type of person where I would just sometimes just sort of hope that things would get gradually better, with time. But now, not so much now at all. I just think issues need to be addressed, no matter how uncomfortable they are, or need to be addressed right away, and then uh, a resolution needs to be um, completed as quickly as possible and addressed. So.
Okay, so stronger person, ethical person. Is that does that
sorry.
equate? A stronger person is an ethical person? Does that equate to you?
Yes, ethically, and also just as maintaining those ethical standards and be vigorous in my objection to those types of things. And so that if I'm dealing in a situation where, like what happened with Rise, that the the person I'm dealing with knows right away that that won't be tolerated, and I'm ready to walk out the door.
Yeah.
Yeah. So,
I also was processing some of the information you shared about your personal stressors currently in your life, but you seem to be kind of talking a lot more about the relationship that you had with your employer. So the employer relationship in your future, whatever that might be, um, that seems to be maybe a point of growth that you're talking about that you have to figure out how to address.
yeah.
What are some things that you're doing right now with the current employers that you have to make sure that you feel like you're able to speak to them about things that concern you?
I'm sorry. The hearing,
Do I need to speak louder?
just a little bit.
Okay. You said that you had some difficulty speaking up to your previous employer.
Uh,
And I'm asking you, in your current work environment, how are you managing that? Are there things you've changed or ways you've
yeah,
grown?
yeah, with the current work environment, I just she's an RN, and good communication. We talk. She knows, she's very well aware of the case and what happened. I sent her, before she even hired me. I sent a full acknowledgement of what happened, and we talk about it on a regular basis in terms of right and wrong, and how important that is. And actually, um, part of the orientation that I do with the new caregivers that are coming on staff has to do with 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 sort of fraud and abuse from a documentation standpoint, and that type of thing too. So it's important to her, and like I said, she's willing to help out in any capacity at all. To, if there's ever a stipulated license, she's willing to work with me in that capacity moving forward.
So your current employer seems very gracious and understanding, and you get along really well. There might be a situation in the future where you don't, and they're not as nice. My question now is what have you done for your ability to address that? How would you address that?
Uh, I think by just being upfront with any employer, um, initial expectations as far as the job, especially when it comes to legal matters, or whether it's billing, supervision. I think you just have to be clear and upfront in terms of well, that has to to be spot on now. There just can't be any gray area involved there. I would be very upfront with any potential new employment to let them know this is kind of what I would, the way it has to be. There just can't be any, everything has to be above board in terms of moving forward.
Okay.
Sorry.
Another question I have, you've been practicing since 1985? Is that when you got your license?
Yeah, January, in 80, I licensed in 85.
85, yeah. So 59 years,
Um,
minus the 3 or 5 that just passed, right?
yeah, it was 85, so that would be 40, 41 years.
Okay. So what you mentioned, your hope for reinstatement was to return to a home health environment. And I'm not sure if you've been thinking about retirement or what that looks like.
I thought about retirement. I would love to be able to, health permitting, uh, be able to work at least till I'm 75. I realize I'm an older therapist. It's different from when I was first licensed in 85.
Mhm.
Everything is different now. So, but I would like to practice at least until I'm 75. And I feel like I'm healthy now. I did uh, part part of what's not included in there is I did have some health issues that I dealt with during the same time of a lot of the stuff going on, and it's kind of an ongoing issue. Actually, at the same time as a trial, I was dealing with kidney cancer, basically, and right after the my hearing. Where she imposed the sentence, I actually had to go into surgery to have a portion of my left kidney removed
Mm.
about a month and a half after that. So I had been dealing kind of with the effects of that cancer for years prior to that also,
Mm.
but finally had because of the growth, I had to actually get the surgery performed and in 2022.
Wow. Yeah. Well, I'm glad you're in good health now. I'm asking a question specifically about your plans for your future employment because you mentioned, yeah, it's clear to me at least that you have a very strong passion for the setting that you've been working in, the home health, and those patients. I like the way that you described the disparity, because there are a lot of places in that area such that don't have care that they need. But that is also considered a high-risk population, and you would be working solo after all of these events. I'm wondering, do you see yourself in any other setting
Um,
in physical therapy?
Really, I'm willing to work in any setting that the board deems appropriate. My background is more in an outpatient physical therapy. I mean, initially when I first started therapy, I worked 15 years at an acute hospital, and back then it was more traditional to rotate 2 years through every department. Orthopedics, pediatrics, general medical, surgical. Uh, Back then we were doing wound care and burn care, not so much now. But I worked for 15 years doing that, and then outpatient. I was a sole provider, so I didn't use any aides or anything. It was just me. Um, but I have a lot of experience in home and office ergonomics and evaluating those sites for safety, and also as far as evaluating equipment needs for the special needs population, and also equipment needs um, for post-acute patients that are coming home from the hospital, that type of thing. Going in and being able to do a house assessment for safety and assistance need, and home modifications that might need to be made also. So that's where the bulk of my experience is. I took a lot of continuing education courses early on in my career to address those issues.
Okay, well, thank you for sharing that. I have one last question. Mr. Gadget kind of stole my question. He asked you whose responsibility, in effect, he asked you whose responsibility is the understanding of the application of the practice of law in PT. Whose responsibility is it understanding the application of the practice of the laws and regs of physical therapy? And I think, did you answer that?
Yeah, my responsibility.
Yeah.
Oh,
yeah.
absolutely.
So I guess a follow-up question that I had was, who did you previously go to, or what resource did you use to make sure you understood the current practice after you had graduated and gotten your license?
Um, then as far as, I mean, in school, we were taught, the regs at that time. This is back in the 80s. We were taught um, the do's and don'ts of the regulation and tested on that as part of the state board exam. Um, uh, After that, unfortunately, most of my continuing ed had to do with just more treatment-related topics of interest, orthopedics, ergonomics, that type of thing. Um, so when the issue came up with the first decision and order, unfortunately, at that time, I had not looked at the um, I had not looked at the regs in a long time, and and it was at that point where I started to research it. I think it's really good now that clinicians with physical therapy, they actually have the California State Practice Act rules and regulations. You can get on the website, so everything is there and it spells it out. So that's a good resource that I intend to use if given the opportunity to move forward. That's a good resource for me to use going forward.
Great, thank you.
Dr. Armstrong, do you have questions?
I do. So you would be, if your license was reinstated, you would be in your third 2-year cycle of continuing ed. Where are you at with keeping up with the 30 hours per license cycle?
I think I'm at about 24 hours right now. So I would have to um, if I were giving the opportunity to come back, I assume that I would have to do another 25 hours.
So you've completed the 30 hours, the 4 hours of CPR, life support, the 2 hours of ethics, and then the 24 hours of,
Right now, I'm at 22 hours of general continuing ed, 2 hours of the ethics. I still need to do the CPR.
okay, so you've done that for the last 5 years. You've kept up on your 2-year cycles in your third cycle, and you have 24 hours left. Is that correct?
Yeah, for the new cycle.
Got it. I have a question about the setup of RISE. So it was owned by a chiropractor, and there were aides. Did those aides also assist the chiropractors?
Yeah, they were actually medical assistants that assisted the chiropractor initially and the medical doctor that worked at the facility.
Were you supervising the aides that were assisting with chiropractic techniques and physical therapy, or just physical therapy?
No, just for physical therapy.
Were you in charge of the competency checks for the physical therapy aides?
Yes.
And how often were those checks?
Uh, Initially in 2014, we did the initial competency check and testing I did with them.
And what was the policy of the clinic for you to reassess? For a physical therapist to reassess after an aide had seen the patients?
Um, typically they got an annual review. So,
No, the patient, so how many sessions did a physical therapy assistant or a physical therapy aide see a patient before a physical therapist would follow up?
um, typically, sometimes the treatments were concurrent together. In other words, it was both of us together. The way the clinic was set up, it was a large room, I would say, like this, and and I had my office in that room, in a corner of that room, and then there's like a gym area, and then there were curtain partitions for the private area, and I also had a private exam room on the outside as well. But I was always in that room there, unless I was doing a private exam, in one of the other rooms when treatments were taking place. But no, I typically try to avoid them um, uh, 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 being the only sole provider for the clients that we worked with.
So you did have an encounter with every patient that,
Yeah, just because of the way the clinic was set up, they had to come through me just to get into the area there. So I would, my office was just sort of right at the front door as they came in, and I could outline their treatment for the day, and then whether I was going to be doing some of the treatment or if the aide was going to be doing some of the treatment, and then they were escorted to a private area curtained off by partition.
okay. Um, in your opening statement, you stated, quote, financial abuse by the company. Did you state that because in your mind it was 70% company and 30% you, or where are you at with taking responsibility? Because that just as a follow-up question from Dr. Brandon.
Yeah, I because they procured at that time, a stamp without my knowledge, to stamp documentation and submit that documentation to the insurance carriers. I didn't realize the scope of that until a little later. And I never knew that they were using a stamp. I never gave them authorization to use a stamp with my signature on it to begin with. So, um, I think it's in my mind. I believe it to this day that 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 70% is, or even more, would is an appropriate number in terms of what they did illegally with my name slapped on it.
Okay. That was my question. So you had absolutely no knowledge of a stamp being made or being used on the patient files or the billing?
Correct.
Okay, and you found out through the
Through
investigation?
the investigation, yeah.
And how many patients per day? What's the estimate when you were at Rise?
It varied. We could see anywhere from um, just for physical therapy you're talking about, or for the whole clinic? Because a lot of the patients got other services too. I would say we were probably anywhere from 20, 25 to I would say 30 patients a day
That you would,
that came through the physical therapy department.
okay, how many patients did you see per day?
I would see it probably at least um, 16 to 16, 18. That's not a normal 8-hour day. Typically, that's more of a closer to probably a 12-hour day, but probably 16 to 18.
And how many patients were the aides seeing?
They were 4-hour shifts, so they were seeing anywhere from probably uh, four to five, depending on the treatment. And then, like I said, there were probably some co-treatments where we both interacted with the patient on that day.
Thank you very much. I appreciate you answering the questions.
Mr. Q, do you have any questions?
Yes. It's sort of continues on the question on the before Rise, were you self-employed You said that you had your own practice?
Yeah, self-employed from 1998 through 2007.
Okay. So as self-employment, you must be pretty keen on what the claim process is, right?
Sorry. Say it again.
Um, you must be very aware of the claiming process. Um, yeah, for your claims, right? For the yeah.
Yeah, the practice that I was in at that time was primarily workers' compensation. Um, So most of the compensation and some private pay clients. And the workers' compensation patients that I saw, it was pre-approved treatments, basically. Um, I, um, I got referrals in San Diego County from, um, um, contracts with, UPS, Federal Express, Marriott Hotels. I saw their employees, and I also did their job site analysis, and their presentations to their employees regarding lifting and body mechanics and that type of thing.
Okay.
But it was on an authorization basis. Yeah.
Okay. At Rise, the
I didn't.
according to the assessment, the total fraudulent billing was about $5 million. Your restitution is about 3 million of it. Can you tell me a little bit of how that come about? That
I never agreed with.
that is assigned to it.
Well, I never agreed with that number. I mean, I just attorney tried to explain it to me. It was some type of formula that they used to assess monetary uh, compensation by the participants in it. Um, um, but I think it was surely because of my name being on everything, even though some of those claims were fraudulent. Um, I think that was the main issue. Basically, was that because my provider number and fraudulent it was used basically almost on a good portion of the billing. I think that's how they utilized it. That's how they decided the monetary um, amount that I needed to pay back in terms of restitution. Uh, But as far as the actual formula, my attorney, I had at the time explained it to me, but I still don't really understand how that.
So the 4.9 is all related to physical therapy billing?
Sorry, say it again.
Is the 4.9 million fraudulent billing all related to only physical therapy claims?
I'm pretty sure it was what was billed under my provider number.
Okay.
Yeah.
So what do you think is the estimate in that period that are legitimate billing that you have submitted through your MPI?
Legitimate billing, I think, was probably closer to probably for those years, probably anywhere from probably $1.82 million, right around there for that.
Sounds good. How do you after gone through this process, which is very difficult for you, and to a degree that I sympathize with what you have to go through. However, one of the questions I have is that if we grant you a license, um, how do we? What do you have in mind in terms of on the new employment? Um, Claims is still going to go out with your MPI number. how do you gonna have any exercise any control over that?
On top of anything that has my provider on it going forward, believe me. I just, I, I don't want to make that mistake of not knowing. That's one thing I encourage the clinicians that I interact with, whether it's PT, OT, speech. I just said, you really have to know what your provider number is being used for, you know. Yeah, I just feel that is very important. Um, for example, I worked at a major hospital in Pasadena for 15 years. I never knew what they billed for me during that 15 years I was there. Not once did they ever say, we're billing X amount for your services for this. So I think it's important that, and definitely for me, because I'll want to know exactly what they're billing for. I'll even want to see the billing to verify that what's going on is accurate. Like I said, I don't want to go through what I've been through over the last 5 years. It's just, especially the incarceration end of it, it's just something I couldn't do again.
So is that something that you believe that an employer would agree to? Have you reviewed their claims based on UMPI? Do you think that's something that's exercisable?
Yeah, I think definitely. I mean, I think if we have the right as clinicians to know what's going on with our provider, what the work setting is.
Okay, thank you so much.
Okay, Ms. McMillan, you have a question?
I do. Thank you. Thank you for coming in, Mr. Ward. I am a public member and I am heavy on personal accountability. And so you mentioned in the beginning that you made mistakes. You made many mistakes. You said it a couple of times. And my concern is um, using the word mistakes versus some bad decisions. So I just would like to ask you, do you see what happened as mistakes or were they some conscious decisions that you made?
Portals. I look back.
So it sounds like your time of incarceration was, you had a lot of time to do some reflections, more so than punishment, because you said, I'm using your words, punishment. Um, Out of that time, when you left, what was your plan? What were your plans?
Was basically come back. I love the all that was taken away, created a void. It's important. Not a lot about. I want to make things able to help. I believe that what I do is, uh, with home health clients or even outpatient, the work that I perform for physical get out. That's what I thought about. Higher level.
So you had a plan, a redemption plan. Thank you. That's the word I wanted. I'm asking you that because generally, and I know this happened to me, I had a business that failed horribly, and I never want to see that business. I never want to take that path again. And the fact that you were incarcerated and you still wanted to come back and redeem yourself in this field, in this public field with people like me who need your services, it says something to me. But it also makes me question, and I'm asking you the question, your decision to go into home health, is that to avoid conflicts? Because you mentioned conflicts, so you mentioned it many times, and your answer was to walk away. Is that to avoid conflict?
It's just an area of interest, area of physical therapy, 2017. I really saw the difference with the special needs rehab team. Really saw the result because it's a special needs San Diego. They had trouble getting clinicians out in the area. Really, because I saw the improvement. And their families who do a lot of caregiver training for well and make them a part of it. That was my main for wanting to go home. I have a lot of experience as well.
So I don't have any questions about your practice because it sounds like you are an amazing practitioner, but you're asking me, somebody who is representing the public of the state of California, to trust that you will do the billing correctly, honestly.
Billing wise, the way home health is set up, depending on whether it's renegotiated that are already agreed upon. Home health, the home health company. Billing wise, I on my own.
So you can you explain what? So I don't know exactly how this works, but I do know, as somebody who is on Medicare, and and how expensive healthcare is right now, and you would be working alone, and the billing, even though you're not hands-on doing it, but it's based on what you submit, correct?
I would, going forward, if I'm working with Medicare or even would definitely make sure that the billing that that's I think with a lot of the different billing softwares now, they're put in a really can't over those accounts will be medical billing software now. Anything that no, I would bill the correct amount. I would do the right treatment and also what I provided. I just think that's important of me moving forward. And even to the point where I would, if I, for example, if I was doing billing on my own, here doing what, why not? They're comfortable. They can relate what they're receiving.
Shouldn't that happen anyway?
Yeah, I mean, when you do evaluation, you definitely set up a treatment plan. Components that is billed, but it's typically billed in a way to where the client will get a copy of the billing statement. Bill, I know with Medicare, they'll get an actual copy of what's billed,
Mm.
so they'll be able to see themselves, okay, on this day, done on it.
Thank you. I don't have any more questions, but thank you.
Do any of the board members have any follow-up questions you wish to ask at this time? Mr. Gatchett, any follow-up questions?
I know that one of the board members asked you about your current employer. For the record, I think the only attachment we have is Exhibit 17. Is that correct? Maya German? Okay, and it's just a name block. Any reason she didn't write a letter on your behalf?
Basically, she was willing to write a letter. I just felt like I just needed to, just that the board needed to know in what capacity I was working for her. It's just been 7 months. But it's going pretty well. But, and she offered to write a letter. I just felt like I told her that I needed some information just so they know exactly what I'm doing.
Okay, so there was no reason for her not to write a letter.
Correct.
Okay, and there's no reason that she couldn't have testified today on your behalf? And her name is spelled Maya, last name German, German, and it shows that she's a registered nurse with a master's in nursing? Okay. And so we don't have any other documentation aside from your statements today regarding your current employment? Okay. I was curious, you were stating about your MPI number. I looked it up online. It doesn't look like it has any restrictions. I'm curious to ask you, do you know as part of your criminal case, do you have a lifetime ban on ever billing Medicare and TRICARE?
5 years.
Okay, you had a 5-year ban. Okay.
Well, there's a reinstatement process for that too.
You haven't gone through that reinstatement process?
Step and that.
Okay, so you don't know if you would even be able to bill for Medicare or TRICARE. And in this case, for home health, Medicare would be kind of an important issue on that. You don't even know if you'd have the access to that.
Oh, correct.
Okay, all right. I have no further questions. Thank you.
I'll ask the board again. Any follow-up? None? Mr. Ward, do you have any follow-up statements you wish to make, having been questioned at length?
No, I just appreciate the opportunity to be here before the board. Like I said, therapy is very important to me. It always has been. I just have, I just need to, in my eyes and for my life, I need to make this right moving forward in terms of not only getting reinstated, but also just being able to provide therapy services. It's a big part of me, and like I said, when I was taken away, it hurts.
Okay. This was not time for like closing statements as much as it was for you to follow up on any if you had things you wish to say in light of those, because I think that Mr. Gatchett has someone you still want to call a witness.
Just briefly.
So I don't need a break. I think we can take a break before, in between, unless someone else. I think we're at 10:48 right now.
Let's go until the next.
All right. So, Mr. Gatchett, you have a witness.
Yes, if Mr. Ward's case is concluded at this point, the board would have, or sorry, the Attorney General's office would call Monty Martin.
Mr. Martin. Please be seated. State and spell your first and last name for the record.
Name is Monty, Monny, Martin, Martin.
Mr. Gatchett, please proceed.
All right, Mr. Martin, who do you work for?
Physical Therapy Board of California.
And how long have you worked for that agency?
Since 1998.
And what is your current role with that agency?
Probation Compliance Monitor.
And how do you get involved in when petitioners seek a petition for reinstatement of their license?
When a petitioner submits their petition for reinstatement, it's my job to conduct an investigation on that petitioner. That's done doing interviews with the petitioner and then the two physical therapists that wrote letters of recommendation for them.
Do you also do a review of the records that the board keeps in terms of what led to the license discipline?
Yes.
Okay. In reviewing the petitioner in this case, are you familiar with James Ward?
Yes.
And how are you familiar?
I interviewed him as part of this petition process.
Okay. And as part of this process, did you review whether he paid all the cost recovery owed to the board?
Yes.
And what is the status on that?
He paid the cost recovery owed June 16th of 2025.
And so at this point, there's no outstanding, at least money owed restitution to the board?
Not for this case, no.
Okay. I want to talk to you about the letter writers. Did you have a chance to talk to a Dr. Kushva?
Yes.
All right. When you talked to Dr. Kushva, did he have a chance to tell you about his knowledge, specific knowledge of petitioner as a physical therapist?
Yes.
And what did he tell you about that?
Mr. Martin, it looks like you're reading from something. Are you reading from?
I'm just looking at my report to refresh my memory of what he said. Is that okay?
I can ask the questions. Did you write a report in this case?
Yes.
Okay. And I believe it's one of the exhibits that we've already actually admitted here in our petition packet. It's Exhibit 11. So I'll just go there for you. All right. Do you recognize Exhibit 11, page 56?
Yes.
All right. What is that?
That's my report for this petition.
All right. And in writing that report, did you document your conversation with different witnesses that you talked to?
Yes.
All right. And would looking at your report help refresh your recollection as to the documentation that you took of the conversations?
Yes.
Were you accurate when you wrote this report?
Yes.
All right. Would looking at your report help you remember what you talked to with Dr. Kushva about?
Yes.
All right. Looking at paragraph 3 on page 63, does that help refresh your recollection as to what Dr. Kushva knew about petitioner as an actual physical therapist?
Yes.
All right. And what was his knowledge about petitioner as an actual physical therapist?
He said he couldn't tell me much about Mr. Ward's work as a physical therapist because Mr. Ward had already stopped treating patients by the time he had met him.
When you talked to Dr. Kushva, did it appear that he knew the specific details of Mr. Ward's criminal trial or criminal conviction?
No.
And why did you say that he didn't appear that he knew the specific details?
He told me, Mr. Kushva told me that he believed that the discipline had something to do with Mr. Warren signing treatment notes, but he reiterated multiple times he did not know Mr. Ward when he was working as a physical therapist, only as an office manager. So he was kind of uncomfortable speaking to anything Mr. Ward did as a PT.
And in terms of Mr. Ward's conviction for tax evasion, did Dr. Kushva mention that at all?
I don't believe so, no.
And then I noted in Dr. Kushva's letter, he said something about second chances. What did he say about second chances to you?
He said he believes everyone deserves a second chance.
All right. Let's talk about Dr. Tam. When you talked to Dr. Tam, did he relate to you a conversation he had with the petitioner about the petitioner asking him to write a letter?
Yes.
And what was the reason the petitioner, according to Dr. Tam, approached Dr. Tam about writing a letter?
I believe he said he needed to get back to work because he was having some financial issues.
I have no further questions of this witness. Thank you.
Mr. Ward, do you have any questions of this witness?
No.
Do any of the board members have questions of the witness? Thank you, sir. Appreciate your presence here. Okay, so just to make sure you have the opportunity to present all the evidence you have or any rebuttal, do you have any rebuttal evidence you wish to present in terms of testimony or anything else?
No, not rebuttal as far as what was just presented and as far as Dr. Tam. He's well versed with I mean, he understood, why I went away and the allegations against me and the ultimate punishment. I probably mentioned to him that I was looking forward to getting back to work, as an actual physical therapist. So, no, that's it.
Okay. All right. Well, it's time for closing remarks. And you will have the last word, but I want to ask Mr. Gatchett, do you have any closing remarks you wish to make?
Just briefly, as I stated at the outset, the Attorney General's office is opposed to granting of this petition in any form. It is commendable that the petitioner is here, that he is gainfully employed, and that he is paying restitution. That is commendable and should be acknowledged. But we also have to acknowledge a license is not a right. It is a privilege. And unfortunately, in this case, there are 4 reasons why this privilege should not be reinstated to this petitioner. 1, I would note, and I think that Board Member Q also noted it as well, the total restitution ordered here was $2.9 million. According to petitioner, in his mind, Rise was at 70% or more fault for the actions that occurred here. 2.9 million is a very big number that is much larger than a minority share of the fault that petitioner is making up of a $5 million fraud. Two, he also still owes $2.8 million in restitution. And outstanding restitution is something this board can look at in regranting this privilege. So the victim, which is the federal government through TRICARE and Medicare, which invariably is us because we're the taxpayers that pay the victim, is still out $2.8 million. And that means that the victims have not been paid whole. And so under a review of a petition for reinstatement, that is against and weighs against him seeking reinstatement of his license. Number three, and this is really for me the biggest part of this case, if petitioner did not have the first discipline case against his license, if that case did not exist and we didn't have that public approval, and we were looking at this criminal case, as abhorrent as it is, in just by itself, and we said, well, okay, I can buy it. You know, you didn't know what was going on. Mistakes were made, fine. I wasn't really paying attention. That's great. The fact that he acknowledges that in 2013 he had an attorney, a licensing attorney, representing him in a disciplinary proceeding with a document from the board telling him that aides and unsupervised aides and signing off on charts was disciplinable material. And yet in 2014, he's in an exact same situation, it's just much worse, where he sees aides not being supervised and being billed for and doesn't immediately stop that is incredibly concerning. It goes well beyond, oh, I don't know. You're on notice and you let this fraud occur. And at the end of the day, petitioner acknowledges it. He's the captain of the ship when it comes to his MPI number. He let this occur. Even if he wants to tell you that the company Rise was, quote, the big problem in this case, he was a conspirator in the felony. He was charged. He was convicted with those felonies, a felony for conspiracy. He had knowledge. He knew what was going on, and he let it occur. And so that's the reason there is a victim in this case. And so for my review of this and for the Attorney General's view of this case, it is clear notice that this board had even provided to him, and he willfully ignored it. And then four, it's not just a fraud that we have here. Sitting alone and by itself, the fact that he was convicted of felony tax fraud is a basis for discipline and would have been a basis for revocation of his license. Why is that? Because our case law tells us that shows dishonesty in a petitioner or in a respondent. And so it's really two prongs here. We have a 2012-2013 tax fraud that he committed, tax evasion, which, by the way, he doesn't seem to tell a lot of the people about in his letter writing. He tells them about, oh, Rise was bad, but he somehow omits the tax fraud part. And we also have the fraud part that Rise was a part of. It is a little concerning that he also is here telling us about this employer that really likes the work that he's doing, and that employer did not write a letter and did not testify. And while petitioner is not an attorney, and I understand that he is representing himself, I would note that in future, if the board denies his reinstatement, that he would probably serve himself well to actually bring a character reference like that and have them testify before this board. So with that, the Attorney General's office is opposed to this. We would ask the board to deny this petition for reinstatement. We do not believe he's proven his burden, which is clear and convincing evidence. He must prove to you that he is safe to practice. If this board does feel fit to grant him a license, we would underscore, do not grant him an unrestricted license. He does not deserve that. If this board is going to grant him a license, it should be on an incredibly long period of probation, and it should have every single one of the letters of the alphabet that the board has in its disciplinary guidelines imposed on it for oversight. He cannot be allowed to see patients and bill for patients without significant supervision. That said, that's only if this board feels that he has met his burden for a license. But once again, the Attorney General's position in this case is the board should reject this petition and deny it. Thank you.
Mr. Gatchett. Mr. Ward, It's your turn to give your closing.
Uh, Just, just in closing, if the license is reinstated, I plan to move forward in becoming a productive therapist and staying within all the guidelines necessary, and definitely providing good care. Uh, Stipulation wise, I would like to practice in any capacity possible, really. But I appreciate the opportunity to be here today and at least present my side of the story here. Thank you.
Okay, thank you, Mr. Ward. Thank you, Mr. Gatchett. This concludes the petition hearing in this matter. The case is submitted, the record is closed, and we are off the record. Board will be in recess for how long?
20 minutes. 20 minutes recess now. Thank you. Okay, thank you for joining us again. We are back from our recess and we are staying on item number 4 on the agenda. And the administrative law judge will continue on case 2.
Thank you. And the record should reflect that we have a quorum and that the board members are present. Karen Brandon, President, Dale Armstrong, Vice President, and members Sam Q and Tanya McMillan. The quorum is present. And we are here before the Physical Therapy Board in the matter of the petition for reinstatement of Christine Diane Spellman. This is case number 720-2025-005494 and Office of Administrative Hearings number 2026050116. My name is Timothy Aspinwall. I'm an administrative law judge with the Office of Administrative Hearings, and I have been assigned to preside over these matters. And may I please have the appearance from the Attorney General's office? Thank you. And for the petitioner?
Yes, Your Honor. Eric Acevedo, it's Acevedo, attorney for Christine Diane Spellman.
Who is present, correct?
Who is present, correct, Your Honor.
Thank you. So I will just reiterate some instructions or orientation comments I gave to you prior to the formal meeting, which is to focus the discussion on rehabilitation. That is the focus here. It's not a time to relitigate prior discipline. Procedurally, the Deputy Attorney General will introduce the case, present a case summary, and present the evidence package, which I will mark and admit in evidence. You will then have the opportunity to testify under oath, in addition to any witnesses you have. And I don't believe you have any other witnesses. Is that correct?
That is correct, Your Honor.
Okay. And the exhibit package that is in the 3-ring binder, are those all the exhibits that you will want to introduce?
Yes, Your Honor.
Okay. And as you know, that the Deputy Attorney General will have the opportunity to question Ms. Spellman, and will the board members. And at the conclusion, we'll go into closed session, and the board will make its decision. So, any questions?
Not at this time, Your Honor. Thank you.
Okay. Yes, thank you for the reminder again. Thank you. Okay, Ms. Wolonsky, do you wish to introduce the case? Your choice. Okay.
How about now? That's better.
Thank you.
Exhibit 1 is the certificate of licensure. and I would like to admit this for all purposes.
No objection.
One is in for all purposes.
Exhibit 2 is the board notice of hearing and acknowledgement of receipt and agreement to appear. Again, I would like to move this, admit this for all purposes.
No objection.
Two is in for all purposes.
Exhibit 3 is the DOJ notice of hearing and request for discovery. And again, I'd like to admit this for all purposes,
Be for all purposes or jurisdictional purposes?
jurisdictional purposes.
Three is in for jurisdictional purposes without objection.
No objection. And for the record, Your Honor, I will not be objecting to any of these on the list.
Thank you. Number 4.
Exhibit 4 is the petition for reduction of penalty report,
Offered for all purposes?
offered for all purposes. Your Honor, for all of these exhibits, I'm offering them all. I would like to admit them for all purposes.
Okay. So 4 is in for all purposes.
Exhibit 5 is the certified copy of prior discipline.
Offered for all purposes.
Yes, Your Honor.
5 is in for all purposes.
Exhibit 6 is the petition for reduction of penalty cover letter and application.
6 is in for all purposes.
Exhibit 7 is the narrative statement.
7 is in for all purposes.
Exhibit 8 is the petition for reinstatement of licensure and the memorandum of points and authorities.
8 is in for all purposes.
Exhibit 9 is the curriculum vitae.
9 is in for all purposes.
Exhibit 10 is coursework.
10 is in for all purposes.
Exhibit 11 is the letters of recommendation.
11 is in for all purposes.
And Exhibit 12 is the Calaveras Superior Court documents.
12 is in for all purposes.
Exhibit 13 is Title 16 California Code of Regulations 1399.21. And I would like the court to take judicial notice of the statute.
We'll take official notice of Exhibit 13.
Exhibit 14 is the court case Flanzer versus the Board of Dental Examiners. And again, I would like the court to admit this for official notice.
Take official notice of Exhibit 14. Thank you. So that takes care of the exhibits.
Thank you, Your Honor. I will be now moving on into my opening statement. Your Honor and board members, we are here today for petitioner Christine Diane Spellman's petition for reinstatement. The burden is on petitioner to prove by clear and convincing evidence that she has been rehabilitated. To provide background, the board issued petitioner's physical therapy assistant license on December 9th, 2014. And on May 9th, 2020, the board filed an accusation charging respondent for conviction of a crime and unprofessional conduct. The underlying facts are that in March 2019, that the Calaveras Sheriff's Office received an anonymous tip regarding an illegal marijuana cultivation site. Respondent was the owner of the property. The officers observed a garage adjacent to the home on respondent's property, and they noticed that 2 garage doorways were boarded shut, one of which had a circular hole with a vent protruding out. And the sheriff observed a full-size residential air conditioning unit on the backside of the garage, and the roof had approximately 17 solar panels. The officer could hear the fans and could smell the odor of the cannabis. The sheriff's office later obtained PG&E records for the property, which indicated that the monthly electric usage between February 2018 and February 2019 was typically 3 to 7 times the amount of the California average, according to the Energy Information Administration. And the records that were obtained did not reflect the energy generated by the solar panels on petitioner's garage. As a result, in April of 2019, the sheriffs obtained a search warrant for petitioner's property. My apologies. The sheriff's office seized a total of 196 growing cannabis plants from the garage. And they estimated that the plants could make approximately 16 pounds of processed marijuana and could sell for approximately $20,800. The officers also found in the garage cultivation equipment, which include extra electrical panels, fans, lights, and a large water tub for watering the plants. As a result, in May of 2019, the district attorney's office charged petitioner with a felony violation for unlawfully renting or making available a property for the unlawful manufacturing of a controlled substance, marijuana. The DA's office also charged respondent with a felony violation for willfully cultivating more than 6 living plants and a felony violation for unlawfully possessing marijuana for the purpose of sale. In January of 2020, respondent was arrested. And in February of 2020, petitioner pled no contest to a misdemeanor violation for willfully cultivating more than 6 living cannabis plants and for unlawfully possessing marijuana for the purpose of sale. The first count was dismissed by the court. In January of 2020, the board sent petitioner a letter asking for an explanation for the criminal case, and petitioner admitted to the board that she did have marijuana growing on her property without proper permits. She also admitted that in January of 2020, she was aware of the arrest warrant and that she had turned herself in to the authorities. She also stated that she had pled no contest to the misdemeanor violations. The board served the accusation on petitioner on May 4th of 2020, and they received a certified mail receipt indicating that petitioner received the accusation on May 6th of 2020. On May 19th of 2020, the board sent a courtesy notice of default by certified mail, which was received on May 21st of 2020. Petitioner failed to respond to the accusation, and as a result, on September 28th of 2020, the board revoked her license via a default decision. That decision went into effect on October 28th of 2020. Petitioner was ordered to pay the board the cost of investigation in the amount of $8,332.50. Petitioner has not paid any of that cost recovery to date. In 2023, petitioner's misdemeanor convictions were expunged, and on December of 2025, the board received Ms. Spellman's petition for reinstatement. It has been approximately 5 years and 7 months since the board revoked her license. Thank you.
At this time, Ms. Spellman, you have the opportunity to testify, counsel. How do you wish, I will swear her in, but how do you wish to proceed in that regard?
Your Honor, I feel it's very important for the board to hear directly from her, but I was kind of guide her on the direction a little bit and ask her a couple questions.
Okay. Do you wish to make any opening or go?
If I could briefly make an opening, I'd
Go ahead.
appreciate it. First, thank you everybody for being here, and thank you, counsel, for your opening. And I think you laid out things fairly and accurately. Ultimately, we're here to have Ms. Spellman's license reinstated. Certainly hope that is without encumbrances on it. We do understand, however, that there is the idea of the payment that still needs to be paid. I'll address that more in the closing, but ultimately, we're not here to relitigate what happened and what you did, but I do feel it's important that you have background on her involvement with it as it relates to her essentially moving past this and what she's done to focus on rehabilitation. Ultimately, you'll hear from her with regards to who's actually growing it, and that is not to say that she does not take full responsibility for her actions, not to say that she was forced into entering a plea against her will, but I think it's important that she provides a totality of the circumstances so the board can clearly understand all the facts. And ultimately, there were 2 counts that she pled to, misdemeanor counts, basically growing too many plants. I think the limit was 6, person over 18, more than 6 plants, and then cultivation for sale. Again, in closing, I'll probably argue it's not uncommon for a person to plead to that. But again, she's going to focus on her recovery and taking responsibility for her actions. And my kind of role here, as I mentioned briefly, I feel that it's important you hear directly from her and a narrative of what happened. With that, I plan on kind of guiding her so we can hit as many important points as possible. With that, I can just say that I believe the evidence will show that she's a person that deeply cares about helping people, cares about her license, that she's very good at her job. Though we don't have witnesses, there are ample recommendations that you'll see in there that show what kind of person and what kind of physical therapist she is. So with that, I'll defer. And
Ms. Spellman, if you will please stand and raise your right hand. You solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth. Yes. Thank you.
Thank you for the opportunity to be here, just to give you a little background about my story and who I am. As was introduced, at the time that I was living in the Calaveras area, I was working probably 6 days a week. Pretty busy there at the nursing home. And I was approached about an idea of allowing someone to use my property. Some of the contextual factors that went into that is, one, I was newly relocated to California, and wasn't acquainted with any laws or anything to do with cannabis. But I did know that it was legal. And actually across the street from the hospital that I worked at, there was a medical dispensary, and some patients at our facility had prescriptions there. That was about my extent of knowledge of that. So I accept the responsibility that this was a decision was made, and it was a poor decision because I normally would not be involved with anything to do with drugs per se, because that's not anything I've ever been involved with. But like I said, what weighed in on my decision was that everywhere around me, this was growing. There would, where you might see orchard trees, normally it was marijuana plants. And there was no, electric fences. There was no guardrails on anything like that. It was very open. People were very open in talking about it. People were employed doing that, quite a few people. And so it seemed like an okay decision at that time. It wasn't until I had an attorney that there was a warrant for my arrest, that my house was raided, that I learned of the actual legal ramifications of it. And so, as I was advised to do, I turned myself in as soon as I found out about that, and did what I was instructed to do, what I needed to do. And shortly after that, also, I received the information from the board, just to respond with what the situation was.
Ms. Spellman, can you elaborate a little bit more on how the marijuana came to be grown in the garage, and how that occurred?
Yeah, my brother approached me about it. It wasn't something that I had any ideas of prior. But he approached me about it, that this was something that was pretty regular, that people that had extra land would lease their land to people that wanted to grow. So I asked just some initial questions about that, and thought it over for a while. But again, I was just working and doing life. And he approached me again, and I hadn't really dug into what that would really mean. So I was kind of relying on him to let me know how that worked. Not even like legally, but just in a business sense or how that happens. Um, and so what my understanding at that time was that if, you have a permit, it's legal, and this person that he knew would, have a permit. If there was something amiss, that it would really come down to a permit issue. And kind of how it was explained to me is like permits, like if you own a property, own a home, if you wanted to add on a deck or you wanted to add on a fence in the front yard, sometimes there's regulations surrounding that. And you have to have a permit. So if something was off that, a permit violation could happen, that would be the something that could possibly happen. But other than that, it was fine. And I think the original agreement was for this person was going to grow outside on my property, which consisted of 5 acres. Um,
Can you tell me, were you involved in cultivating the marijuana yourself?
no,
Were you involved in any sales of the marijuana?
no.
Um, you gave us a narrative, but if I could refer everybody to Exhibit 7, it's a narrative statement. I just want you to identify. Is this if you could take a look at it,
Yes,
is this an accurate statement of what occurred? A summary of what occurred?
yes,
Okay. Is there anything in here that you think is inaccurate?
no.
I'll leave it to the board if they specifications on that instead of reviewing it. To kind of focus now on your, we just say kind of rehabilitation. Can you tell the board what your sentence was after you pled to the 2 misdemeanor counts?
There was a fine to be paid and a informal probation of 3 years, which I think the fine was around $1,500. And I completed the informal probation without any issues
And the fine has been completely paid? on the
and
criminal?
paid. Yes.
And I believe counsel alluded to in their opening statement, have you since then had those charges expunged from your record?
Yes.
Can you tell us a little bit about what you're doing, what you currently do now? Are you currently employed?
Yes, I've been working as a rehab aide since February of 25. Um, and so I've had the opportunity to be in the physical therapy environment, helping as a second set of hands sometimes in treatments, make sure to maintain all of the equipment. We have it's a short-term rehab hospital. They have a um, sort of a daily schedule where patients have specific times that they come to therapy, and as part of tech duties, you go and pick them up and bring them to the therapist, and make sure that any issues are kind of ironed out before they get to therapy, so they have a successful treatment. But also during treatment, maybe running to get things that are needed, oxygen or um, orthotics, whatever is needed, a nurse. Um, and then also in more recent times, I've been asked to help them work on their scheduling. So I've gone through a process of learning how to do that. Um, so yeah, that's currently what I'm doing.
With regards to, have you done any continuing education since your license was revoked?
Yes, all along I've been continuing my education, and the first couple of years it was pretty difficult. I didn't have um, the money to pay for CE, so I did a lot of looked around for free CE courses, which I found a lot of valuable courses out there for the APTA and also the Veterans Administration. And then more recently, since I was employed, was able to continue education courses, and also as a part of employment, I'm able to access courses through MedBridge.
With that in mind, if I could refer you to Exhibit 10, starting on Bates stamp 77. Could I have you look through these? And I'm going to ask you a question on this. Are there other courses that you've completed that are not included in this?
Yeah, there are additional courses than this list.
Can you explain those to the board?
Yeah, the courses that are in addition to these would be completed in 2024 and 2025. And they specifically more pertain to the setting that I'm in. So more of like spinal cord injuries, brain injury, stroke recovery, ethics, and the CPRs in there as well.
Jump around a little bit. So back, you received an accusation from the board, and subsequently, there's evidence in the exhibits that there was a default judgment entered against you. Can you explain why you did not respond to the accusation?
Yeah, during that time, I was trying to find my way with financially, and what my next steps would be. Uh, I somewhat naively as well did not understand the gravity of that potential, but I financially did not have the means to request to be a part of a hearing.
Did you consult any attorneys at that time?
No.
Going back to the default judgment, you recognize there was an amount levied against you, roughly $8,330, correct? Can you and it was stated that that none of that has been paid. Can you explain why not?
Yeah, for similar reasons, I didn't have the financial means um, to attempt that. Not until maybe more recently, but I know the attorney that I had at the time advised that that was something that we could discuss in a hearing at this point in time.
At this point in time, if you are reinstated, do you have the ability to pay some or all of that?
Yes.
And are you willing to do so?
Yes.
I want to reflect a little bit more on kind of some positive things that you've done since then. It's come to my attention that you've been involved in assisting people on a travel thing. Can you kind of explain some positive things that you've done to which you think is helpful to the public?
Yeah, I feel really grateful that I have the opportunity to work as a rehab aide or tech. And during that process, just being amongst other therapists, found a fellow long distance hiker who also enjoys the idea of a through hike. And we were talking about the Camino de Santiago, which he had completed multiple times. And in asking him for more information, just because that's something that was on my list to do in life, he mentioned that there was two guys that are friends that had been hosting groups to do the Camino in wheelchairs. And I had never heard of it. And he expressed that he was going to be going, and there was a process to be interviewed, to be selected as a volunteer for this group. Um, so I made myself available, signed up to um, be a volunteer, and I actually got an interview. You had to write like an introduction letter why you wanted to volunteer. Um, and I got a call to be interviewed, and then I was eventually selected to be a volunteer on this trip. And on the trip, I found that they explained that they probably interviewed over 600 applicants. Um, or they received 600 applicants. They interviewed about 250, and I was one of 50 selected.
What kind of things did you do on this?
Yeah, so it was a long distance hike to be officially complete the Camino, which is a 500-kilometer event. You can do the last 100 kilometers. And so that's what we did, which is about 64 miles, and with a gain of quite a bit of elevation. I don't know exact number. So on this journey, there would be a person in a wheelchair and 6 people to assist. And so anytime that we came over something that was a technical area, that the person in the chair might need assistance, we were there to help them, or extreme up or downhill events, we were there as well.
I'd like to jump back to your employment a little bit, and actually your application for this renewal. You were interviewed prior to being here. Is that correct?
Right.
Okay.
Yes.
And so I'd refer to basically maybe referring to Exhibit 4 for the record here, which is the petition for reduction of penalty report. Just so the board has an idea of who these people are, and there's one, I just want to get ahead of it. 2 other people were interviewed on this. Can you tell me who Hassan Wine is? And this would be on Bait Stamp 29, and what your relationship is with this person.
Dr. Nguyen is a physical therapist that I met in 2020, after my criminal legal issues. He hired me as a PTA while my license was under review. I worked out of the area. I was living in Sacramento at that time. He was a regional director in that area. The supervisor and management at the facility where I was working was speech language pathologist. So he came regularly to visit our site, and we quickly became friends and discussed patient care. Any questions or concerns that I had, I could go to him. Very supportive, and the whole team there was a really good team. So at the time that the board revoked my license, I let him know as soon as I found out. But there wasn't a lot of, notice to give. And he was not aware of my prior situation. I just wasn't sure how to frame that when looking for a job. But and I also wasn't sure how to explain what was going on to him. But I did stay in touch with some of the other therapists there, just kind of loosely over the next couple of years.
One other person was interviewed, Marie Easterday. Starts on Bait Stamp 31 for the record. Can you describe who this person is?
Yeah, Monica Easterday is a physical therapist where I currently work. She, oftentimes I've helped her during treatments, and I asked her if she would be willing to write a letter for me because many times she complimented me on my attention to details and always being ready to help the therapist and kind of anticipating what the needs might be. Um, and because of that, I felt very comfortable explaining to her my situation and that I was in the process of trying to petition for my PTA license.
Want to bore the board too much here with stuff. We really do want to focus on rehabilitation. This is probably a little bit of a unique situation, but are there other steps that you have taken or plan to take that you can express to the board and His Honor about why they should give you a second chance at your license?
Yeah, I think that, after going through this process and realizing how much um, I enjoy helping people and how much I enjoy being a physical therapist assistant, that I wanted to continue to pursue reinstatement, as well as letter writers that I have and friends in the profession continued to support me and um, want to see that happen as well. I I think it means a lot to me to carry these titles that we're given, and so I haven't taken any of this lightly at all. Um, I you know took the time to understand how poor decision making happens, and for me personally. Um, and spent a lot of time to uncover those blind spots. Um, I would say prior, I thought I was pretty good at making decisions. But now I know a little more about myself, um, enough that I, trust that something like this would not happen again in any facet of life. Um, and I know that I have supportive people around me that I can go to in any stressful times. Um, I think a greater awareness of work-life balance as well is something that I've cultivated and I foresee going forward with, um, that, to take care of myself as much as I'm wanting to take care of others.
And I'll probably finish with this last question, but just since the underlying criminal charges are related to cultivation of marijuana, do you use any illicit drugs?
No,
Did you at the time?
no.
With that, Your Honor, I don't believe I have any further questions. Is there anything else you'd like to add before council asks you?
No.
Ms. Walensky, do you have questions?
Yes, Your Honor. Petitioner, I'm just going to ask you some brief questions about your work history. You stated that you currently work as a rehab technician. Is that correct?
Yes.
And after your license was revoked in October of 2020, where did you work?
I had various jobs. It was kind of difficult being under probation, and until my record was expunged, I had tried to kind of do my own businesses to earn an income. Um, and then after my record was expunged, I was able to work at the Salvation Army. And I was there until I was able to secure a rehab tech position, which was what I was pursuing um, since expungement.
Thank you, Petitioner. I'm now just going to ask you some questions about the underlying accusation. Do you agree that in between February of 2018 and February of 2019, that the electrical use of your property was 3 to 7 times the California average?
I believe that report is accurate.
And do you agree that in March of 2019, that your garage roof had approximately 17 solar panels?
I don't know the exact number, but yes, there was solar panels there.
And do you agree that your property had approximately 196 plants?
Yeah, I didn't know that until that report was written.
Were you aware that your property had approximately 16 pounds of processed marijuana?
Only after reading the investigators' reports.
And were you aware that those plants could sell for approximately $20,800?
I had no prior knowledge of that until reading their report.
And can you clarify, when did you read that report?
Once I had an attorney and was going to court.
And this was on your property in Calaveras County?
Correct.
And did you live in that home?
I did.
So when you went to your home, did you see any of those plants?
No, this was in a garage, a closed-in area that this person was using, and I didn't have anything that I was using in there, so I didn't have like a need on a daily basis to go in there.
Can you recall approximately how many times you looked at at the garage when you came home?
Well, the garage is about 50 feet or so from my home, so daily.
So when you returned home every day, did you see the solar panels?
Yeah, I know that the solar panels were there.
And petitioner, I just want to clarify, you stated earlier that your brother approached you about growing cannabis on your property.
Right, yes.
And was it your brother growing the cannabis?
Um, no, not to my knowledge. It was this other person, an acquaintance of his. I did not know this person prior or even now.
When you returned to your property after work, did you see other people on your property working on the cannabis?
No.
And when your brother asked you if he could use your property for growing cannabis, did you research the laws on growing cannabis?
No, I didn't. That was where I think the problem occurred. Had I taken the time, my decision would have been differently had I known all of the ramifications of that.
And after your brother and after the cannabis was growing on your property, did you research the laws on growing cannabis?
No, I didn't actually understand the law until I was with my attorney.
Can you explain to the board, why did you not research those laws?
Yeah, I was working at the clinic, well, the nursing home in town, and probably 6 days a week, more than 8 hours in a day. I was just very busy. It wasn't something I was associated with and as I explained, driving from my house to where my workplace, there was hundreds of acres with marijuana plants.
So it is your testimony today that you saw the 17 solar panels on your garage every day,
Yes, absolutely. I knew they were there.
and at no point you researched the laws on growing cannabis.
No, I didn't.
Thank you. And now I'm going to ask you about after the board filed its accusation. Did you receive that accusation, petitioner?
Yes,
Did you read that accusation, petitioner?
yes,
And did you receive the courtesy notice of default?
yes,
And did you read that courtesy notice of default?
yes.
And can you explain why you did not respond to the accusation?
Yeah, as I stated earlier, I was naive thinking that if I explained the situation they asked for my response, that was enough explanation for a decision to be made. But also, I did not have financial means to hire an attorney to represent me at a hearing such as this.
When you received the courtesy notice of default, did you read that document?
Yes.
Thank you, Ms. Spellman. I'm now going to ask you about what your plans are if your petition is granted.
If I'm reinstated,
Oh, sorry, petitioner. That was just a header, not my question yet. I was taking a breath. Do you understand that a license is a privilege?
yes,
And do you understand that if the board reissues you a license, that you must abide with the law?
pardon me. Yes.
And if the board reissues you a license, do you intend to research the law?
With any sort of venture that would require there be a personal business or financial matters, I would absolutely consult all the sources I needed to be aware of what laws would pertain to that.
And in 2020, you failed to respond to the board's accusation. Uh, if the board contacts you moving forward, will you respond in a timely manner?
Absolutely.
And do you understand that if you are granted a probationary license, any violation of any of the probationary terms will be brought to the board's attention for disciplinary action?
Yes.
Thank you. No further questions.
I just have one question to make sure I heard correctly. Did you say that you did live at the house or that you did not live at the house?
I did live at the house.
Did live at. Dr. Brandon, you have a question.
Thank you. A follow-up question from the judge's question. Were you living at the house by yourself?
For some of the time, I was married for a time, and so my spouse was there. And then for a certain time, I was on my own there.
Okay. During the time frame that your brother had allowed someone else to use your garage, was that the time before or after the other person was at the house?
It overlapped somewhat. Yeah.
Okay, so the other person was aware of
hmm
how much of the information?
Same as me. Apparently not enough. Yeah, no, we didn't understand that this was against the law.
Okay. I'm sorry, I just jumped into that, but I thank you for being here. I had a couple other questions. I was trying to understand maybe the relationship that you had with your brother regarding his request or any hesitations. Can you describe the relationship between you two? Is it someone, a relative that you're very close to? Is there any kind of coercion?
Um, like I said, I had not been living in California for some years. So I was newly back to California. And during those years away, I was kind of estranged from my family. Um, I think I had talked to my brother over the phone maybe twice in 12 years. So coming back to this area of California, it it was nice to reconnect. And it seemed like he had accomplished many good things in the time that we were apart. He has a family. Um, so I thought that he was doing quite well for himself and his family was happy. That's what I saw.
So in no way was he um, suggesting or pressuring? Did you feel any pressure or, um,
I think in hindsight, yeah. I think our dynamic growing up together was more so, you know, bully and little sister. But, it had been so many years that that's not necessarily how we related to each other. I didn't feel. But yeah, I think in hindsight, some of those same patterns were there.
but there was no overt threat?
No.
And was there, you mentioned that you were going to be getting paid. How much did they suggest or did you get offered? And
I think it was like $500 a month for rent.
Clarify the last part, was that for rent?
Mhm. Yeah, for rent.
and then from the time that you said yes to your brother and they started to use the garage to the time that that you got arrested, what was that time frame?
Um, uh, it was quite long, actually. I think it was when I first learned when they came to my property and had a lot of permit violations. I worked on correcting those, and then I eventually sold that property and moved to Sacramento. And in between that time, I had 2 different jobs in Sacramento, not in that area. And so I think it was like over a year had transpired before I learned that there was arrest warrant. And then that's when I contacted an attorney and turned myself in. So it was time later.
And you're saying from the time that your brother brought the idea to you to the time that the arrest occurred was a year?
Mm-hmm.
Okay. I'm just interested in that based on understanding if anyone else had come to you and suggested neighbors or your ex-wife or anybody. Is this normal or should we be worried or did you get any?
Yeah, after when the permit issues happened, I contacted an attorney that my brother recommended in that area, and he just explained that there wasn't anything that he could see that he couldn't really advise me without any charges. I was just wondering where does this go from here? What does this mean? Um, and he explained he couldn't really tell me based on that point in time.
Okay, so that was one moment in time where you did reach out trying to figure out after the permit violations came.
Yeah.
Um, this other area of questioning, I just want to understand when you were reached out to by our board with the letter and kind of, can you tell me, you indicated you felt like you needed to get an attorney, but the question that was posed was about the payment, right? And the fine. Um, what was your concern? Were you considering that you would not want to reinstate?
Not at all. I always wanted to do whatever I could to remain licensed or, eventually reinstated. I just didn't have the funds. And when I saw that figure, in addition to um, having just completed having an attorney and representation for the legal aspects that were occurring at that time, um, did not have the means to pursue that.
Did you reach out to the board to let them know?
I don't recall. I don't think so.
Did you know that you could?
No.
Of course, as the judge had mentioned, we're not re-litigating that old information. But moving forward, I know this feels so far from physical therapy practice, right? But are you understanding the relationship between criminal behavior or being charged with these misdemeanors and your practice? How would you describe that to us or anybody?
Yes. I would describe it as more of like a decision-making capacity. Um, being informed. How do you make decisions? How do you weigh different options of things? I know that the specific um, statements are one of safety. Um, yeah, I think I haven't ever had anything to do with illicit drugs, nor would I in the future. Um, but also being ethical and honest about everything that I do.
Okay. And then my final question was about, while obviously you're right and you were able to get your misdemeanors expunged, um, many people do that for different reasons. What was your primary motivation?
Um, Primary motivation is to um, clear my name, sort of, to make sure that that's everything in my power to um, make sure that I'm on a good path, and to restore myself.
Okay, thank you.
Thank you.
Dr. Armstrong.
I have a few questions. In the documents that were submitted to the board, there was a New Mexico ID with the name Christine Childs with the same, your photo and your date of birth found in your home. How does that play into this situation, or does it? Or could you explain that?
I'm not sure it does. Previously, I was married some years back, and my name was Child.
Okay, thank you for clarifying.
Last name.
So you moved from North Carolina to California?
Yes.
Okay, and then you were licensed in California, December 9th, 2014.
Yes.
Okay. And who paid the electrical bill? 'Cause it was very high.
Yeah, it wasn't me.
So that was a separate bill from your house? Because usually electrical bill comes by the address, so how was that
Yeah.
work out?
Well, with solar, you have like a true up payment time, and that's if I remember correctly, like twice a year. And that person took care of the electrical.
Okay, so there was so you had an electrical bill for your home, and then there was a separate bill that came for solar, and what did you do? Turn it over to the person, or how did that transpire?
Yeah, no, there was one bill for electrical.
Okay.
The solar panels were also for my home.
Okay.
So yeah, I just gave that information to my brother.
And then he paid you for the bill, or?
No, the bill was paid at the utilities.
Okay. And there seems to be sort of a pattern, and getting into your rehab, there seems to be a pattern of sort of denial or ignoring, for example, the response to the board or what was happening on your property. How have you internally changed just ignoring things that are happening or coming to you so that you can move forward if you are to get your license back?
Yeah, I think just having a solid understanding of how mistakes were made in the past with decision making, specific for me, but also, having a framework to go forward with, being, um, to investigate anything on my own, um, make my own decisions, but also, you know, going through mental health counseling to just kind of understand where um, I can have a greater impact in my own thinking without needing other people to weigh in on a decision, that I can own those for myself. But also, just a sort of a test if you were making a decision on something and kind of not sure either way, is this something that, if you put it in the newspaper, um, for everyone to read, does that help you decide one way or another? That's just one snippet, but I'm sorry that it comes across as denial in any way, because I am very much a communicator, and I very much don't usually just walk away from things without asking lots of questions. Um, in this particular case, in the past, I think because of the family dynamic there, it sort of blinded me to some areas of questioning. Um, but now in my current employment, if there's anything, or in life, if there's anything that's in a gray area, I make sure that I ask for clarification, um, just so that I can really understand. If there's some area that I'm not quite grasping onto, I will ask for more clarification.
Have you continued to receive psychological support? And when did you start and when did you end? Or are you still continuing to receive?
I'm not currently, but I did seek counseling for about 2 years. And I had some goals, just as we do in physical therapy, to accomplish, and I accomplished those. Of course, I'm always open to growing and learning and returning to that if I need to. Um, but yeah, I kind of understand better family dynamics and what goes into why I made the decisions that I made, and how I can make better ones going forward, the type of things that are stressors for me, um, and how to avoid those.
Thank you. That's all of my questions.
Thank you.
Mr. Q, do you have questions?
For coming in. My question is more around, do you still have a relationship with your brother?
No.
Um, the One of the things I wanted to get your thoughts on is that how do you how do you make decisions now with anything associated with your profession? That means not just from a clinical or technical sense, but from a sort of living a life and a business um, sort of activities and associations that you have to, daily life, you have to make those decisions. Are you How do you see yourself different in pursuing those questions? Are you within guidelines of, just legal guidelines or the privileges that the license grants you, right? How do you see yourself different a couple of years ago when you obviously did not um, put those questions forward to stay away from this type of it's on to me it's unrelated to the practice of physical therapy from a technical sense, but um, it is a concern, obviously, is that some situation arise again, and what prevents you from avoiding it again.
Well, I think the situation that I've been through is a very big teacher. But I think having more confidence in myself and my ability to speak, my ability to make sound decisions, um, I've practiced that since that time. And yeah, I'm definitely different now in that way. Um, I mean, I could share examples of workplace setting, decisions. Um, just being focused. And like I said, if I have any questions, relying on some of my training to lead me to make those, to have good judgment in a situation. Sometimes things are happening quickly. Um, that might be different than in personal life. Maybe you have more time to make a decision. But I've tested through those and I feel confident in the clinical aspect and as well in personal, just sort of the boundaries that I've created for myself with family or um, staying away from anything that would be negative. Um, yeah, I'd say confidence is probably the biggest one.
Thank you.
Ms. McMillan, do you have questions?
Yes, I do. So first, I want to say I am pro cannabis, and I am so glad that it is legal. So I'm gonna put that out there. Um, I agree with your attorney that it is not uncommon for there to be cannabis permit violations. I am aware of that, so you are right on the money with that. My question is, how did the authorities find out about the the cannabis business?
Yeah, the my attorney at the time, through the investigator information, said it was an anonymous tip from a neighbor. Um, I That's all I know. I mean, I have my thoughts about it, but there there wasn't anything on my side where I was trying to hide anything necessarily. There, like I said, there was lots of people growing things right around me. And initially, like I said, the person was going to grow on my property outside. So I did come to find that there was certain, people were completely against it. This is when, I mean, cannabis is legal. Um, and some all for it. I'm kind of neither one. I recognize that it provides benefits for people, but it's not something that I've ever had experience with. So I'm not trying to advocate for anything. I was really didn't understand other
I
than
didn't take it as you were advocating for
yeah.
it. So,
Well,
um, but I do understand. I'm really glad that you showed up today. I applaud you for that. I applaud you for addressing whatever triggers happened that led you to seeking support for your personal character and also as a result of the PTBC doing what we do, that drove you to take some courses and address some professional growth as well. Um, but I also understand that when you're approached by a trusted family member, um, and they're literally asking for permission, I can 100% relate to not doing the extra legwork. And when I say that, doing the research about permits, and you were approached by a trusted family member, and I'm so happy that President Brandon asked the question about your relationship with your brother, and I hope that you and your brother, that relationship is mended, that it gets healed at some point. So you do plan on paying the fines.
yes. Now that I have employment and I have a path forward, yes.
I have no further questions.
Thank you.
Okay. Ms. Wolanski, do you have any follow-up questions? Mr. Acevedo, do you have any questions on redirect?
Just a clarification or reiteration on this. it was talked about, that this grow is on your property. Through this process, do you recognize that anything that happens on your property is essentially your responsibility?
Yes.
Through this process, the same question. You recognize that essentially the saying that ignorance of the law is not a defense, but do you recognize it's your responsibility to learn the law?
Yes.
That's all I have.
Any further questions by board members? Hearing none, this would be the time for closing arguments. Then. Go ahead, Ms. Wolanski.
Thank you, Your Honor. In a proceeding for the reinstatement of a revoked license, again, the burden rests on petitioner to prove that she is rehabilitated and that she is entitled to have her license restored. She must show by clear and convincing evidence that her efforts toward rehabilitation have been successful. The board can consider Title 16 California Code of Regulations, Section 1399.21, and they can consider the following criteria: the nature and gravity of the crime, the length of the applicable parole or probation period, the extent to which the applicable parole or probation period was shortened, lengthened, and the reason the period was modified, the terms or conditions of parole or probation, and the extent to which they bear on the applicant's rehabilitation, and lastly, the extent to which the terms or conditions of parole or probation were modified and the reasons for that modification. We commend petitioner for her steps towards rehabilitation. However, we do express concerns about her license being reinstated outright without any probationary terms and conditions. Petitioner's property did not have a small business operation. Although she owned a property with approximately 196 plants and 17 solar panels and had high energy usage for approximately a year, petitioner did not take the appropriate steps to research before the operation started or after it started. It was only when she was arrested that she realized how much cannabis was growing on her property. The people are concerned in relation to the practice of physical therapy. Will petitioner exercise due diligence to comply with the laws and regulations governing physical therapy? She is interacting with patients, the public, and must navigate complicated regulations and the standard of care. If the petition is granted, petitioner must pay the cost of the underlying accusation prior to reinstatement. In the default decision, petitioner was ordered to pay the board for the costs of enforcement in the amount of $8,332.50. Thank you, Your Honor, and board members.
Thank you. Mr. Acevedo.
Thank you, Your Honor. And I'll be very brief. Ultimately, I believe that Ms. Spellman is a prime candidate for reinstatement, and I believe that the evidence, particularly through her testimony and but also the steps she's taken since this incident show that. Ultimately, we'd be here to ask that for an unencumbered license, obviously, but I understand that there's certain hurdles to that, and she understands that as well. With that said, we understand that a fine needs to be paid, and if there's other conditions that need to be met. I think that through her testimony today and through the evidence presented, however, that I believe the board could rest assured that she has learned from this, that she's taken positive steps. She just didn't sit there and kind of take it, though she didn't respond initially. She took steps to seeking counseling to better herself, continue in education. If you look through the exhibits in here and the letters of recommendation and the investigation report that she briefly touched on, there's one consistent thing on all of those is that everybody thinks that she's very good at her job and a valuable person in the field. And I think that is hard to find and a valuable asset to the profession. I think she recognizes, this is a type of incident that she recognizes that, any violation of the law will be related to her license and potentially reflect poorly on her profession or any profession, whether it's license, physical therapy or others. Um, and with that, this particular incident, I cannot see repeating itself. It's one of those ones that it was a tough learning lesson. I appreciate the board's understanding of the familiar situation she was put in. But ultimately, with that, I strongly believe that she's taken steps to rehabilitate. It will not reoccur. And with that, we respectfully request that her license be reinstated with the appropriate terms, the terms you feel appropriate. Thank you.
Thank you. That concludes the petition hearing in this matter. The case is submitted, the record is closed, and we are off the record.
Thank you so much, and thank you all for being here.
Thank you, everybody.
We are going to go into closed session now. We're going to recess for that, and we will be back in the afternoon. Okay, welcome back. We are going to be continuing on our agenda for today, PT Board of California Day number 1, and I would like to move to item number 7C, which is the update from the Department of Consumer Affairs Executive Office. Thank you. Push the button so it's green. And I'm sorry, I didn't get your name. Would you introduce yourself?
Hi, good afternoon, board members and staff. My name is Jarrell Abutin. I am a business analyst from the Organizational Improvement Office on behalf of the boards and bureau relations of the California Department of Consumer Affairs. Thank you for giving me the opportunity to provide an update from the department. So first of all, the secretary announcement. On May 12th, Governor Newsom announced the appointment of Rohit Chopra as Secretary of California's new Business and Consumer Affairs Agency, which officially launches July 1st, 2026. Secretary Chopra previously served as Director of the U.S. Consumer Financial Protection Bureau and as a Commissioner of the Federal Trade Commission, where he led major efforts to crack down on junk fees, corporate misconduct, and unfair practices harming consumers and small businesses. We are excited to welcome Secretary Chopra and look forward to carrying out our consumer protection mission under his leadership. We will continue to keep board and bureau leadership informed about the upcoming agency reorganization. Second of all, the return to office. DCA, along with other state departments, will transition back to 4 days a week in office beginning July 1st, consistent with the governor's executive order, which was originally to take effect on July 1st, 2025. DCA issued a department-wide email with guidance surrounding telework agreements. As we prepare for this transition, DCA wants to recognize board leadership's efforts and partnerships as we work together to support staff. The final training updates. On May 26, DCA launched its internal defensive driver training available. This training is mandatory for state employees, including board and bureau members who operate vehicles on official state business. This 2-hour interactive session covers safe driving practices, rules of the road, required forms for state travel, and accident response procedures. Board members can register for board member orientation training or defensive driver training using DCA's learning management system, also known as LMS. If you have any questions on accessing LMS, or if you would like to check to make sure you are in compliance and with mandated training requirements, please contact us at memberrelations@dca.ca.gov. And then that concludes the DCA update. Thank you, and I'm available for questions.
Thank you very much. I heard you say the return to the office was back in effect as of what date?
July 1st.
So it's not, yeah, so people are preparing for that.
The preparations, I'll get back to the board and I'll get back to my management to make sure that you have details on it. But we are hoping to get all telework agreements in before July 1st of this year.
Okay.
So as of now, that's what I have detailed.
Okay, well, thank you very much. Appreciate it.
I'll provide you a little bit more of a brief during the executive officer's report also.
Thank you. That sounds great. Thank you so much. Any questions or comments from the board? No? Okay. Any public comment on item 7C? Not hearing any. Thank you so much. Appreciate it. Okay, we're going to be moving on now to number 8, which is review, discussion, possible action regarding an increase in the exempt position review. We have a task force that worked on this, and also Catherine. Oh, no, sorry. Are you Catherine? Yeah, okay. I thought that was you. I apologize. Catherine from HR is going to do some explanation of the packet. Oh, I'm sorry. Sorry, wait a second. I'm sorry. I'm going to send it over to the task force, Sam, who's going to give us a overview of where we are now with the decisions.
Yeah, I thank you for coming in and helping us. It's Ms. Trejo, right? Yeah, we met. Thank you for supporting us on this process, and we had multiple meetings, and also I just heard that Miss Lay has retired. So as a board, we wanted to send our best regards for her. And if you can get the message, yeah. And again, we thank you for your time and being here today to give us more insights as to what maybe the sort of a newer process or definition of the non-categories are, and what the expected processes could be, and then that would help us sort of narrow down a little bit on what our decision. We already have the staff and board has already, the committee developed a package, the EPR package that we presented some histories of the EPR request process, multiple EPR process. And we also made an effort to do some of the comparatives between different boards in terms of size, simplicity, and budgets and all that. And we also made some efforts as to going through the state guidelines in terms of the item classifications and the steps and etc. And we made some comparatives between boards also. And that is going to be in the package that we're going to be submitting to HR. And there are, at this point, we have sort of 2 levels of lettered levels of recommendations or requests, but depends on today's understanding that we obtain from today's meeting. We probably will do a modification or come up with another decision that's different than what we are written down. So yeah, we would love to open up for you to shed some more light as to what the process are. Yeah.
You got it.
Is it on now? Good? Yes. Yes. Okay. So you do have to provide the justification. It sounds like you've already compiled, a justification for that, and it is submitted with to CalHR for approval. They ultimately, decide on the level based on your justification. What levels were you looking at this point? Was it level L?
Yeah, so there are 2 levels that we are considering. One is level L, and the other one is level G.
G. Okay.
Yeah.
Okay. were there any specific questions you had regarding those two levels? Or what were you considering? You were considering just those two levels?
Yeah, so this has not been a full board discussion yet, but between the committee members, which is me and Ms. Macmillan, that we are considering both, but with the focus on the G, but also wanted to explore the options of the non-lettered,
Level none.
level.
Okay.
You know, depending on, we're probably gonna have some questions. I want the full board to be aware of what are the, let's say, the existing. If you can give us some procedure or existing procedure requirements and steps that you know, on the L and G, how that works versus on the non
Okay. Okay.
classification
Got it.
process. Yeah.
Well, currently, the position is at level M, like Mary. That range is from 9,771 to 10,884. The next level up, level L, there is an overlap. So the minimum is 10,250 to 11,418. So there is an overlap between all of the different levels. It is recommended to not skip levels because you're thinking from level M all the way up to level G, which is that range is from 12,629 to 14,063. And then level none does not have a maximum tied to the salary. So there's more flexibility if you went with a level none. But ultimately, it is up to the California Department of Human Resources to approve what level based on the justification. So if you decide that you want to go with level G, CalHR may ask for additional justification. They could deny the request altogether, or they can modify it and say, you know, level L is more.
Okay. So does the non-classification have a starting point?
The starting point would be what the position is currently at. So the starting point would be 9,771. And then the maximum would be, let's say you requested like a 5% increase for the executive officer, that would become the new maximum, the new top out. But it's not, there's no actual maximum. So let's say the next year you requested another 5% increase, that would become the new maximum. So it's not tied to a specific max, just like level L, for example, the maximum is 11,418 and you can't go beyond that. So there's more flexibility with a level none, if that makes sense.
What I hear, is this correct to say that when you're in a band, you're moving up inside the band?
You're moving up, yeah.
I mean, to the max, is that?
To the max.
In the begin, wherever you start to the max.
Yes.
And then to get to another letter, you have to write one of these, the justification.
You have to write a justification. Even for level none, you have to write a justification.
So then for level none, since there's no max, how does someone move to the next amount?
Hi, my name is Olivia Trejo. I'm the HR chief. Thank you for having us here today. So with level none, there's a little bit more flexibility on what the board can decide, and it can be part of the evaluation process and doesn't have to be a discussion necessarily in open session. But you still need to do a justification on the accomplishments of the executive officer since the last increase, et cetera. So if you want to go with a specific letter, then that's usually done in open session because you're focusing on the position, not so much on the executive officer, but more of the position, what has grown, more complexity in the license type, more regulations, et cetera. So the justification has to be a little bit more tied to the position versus the incumbent, where in a sense, at the end of the day, it's tied to the incumbent, but the increase for the executive officer to level none can be done in closed session as part of the evaluation. So if you decided to vote for a 3% increase as part of the evaluation in closed session, then that would be the new max if you decided to go with level none. So level none is a little bit complex, and each level identified to an executive officer position has a different salary band. It's not all the same. Like you'll see for level M, anyone identified as level M, it's the same salary band. With none, it's not the case.
Yes. So you're saying it would be then, a none would be then tied to the eval, and it would be
May.
annually.
Correct.
Whereas if they were in a band, it would still be tied to the eval, but it wouldn't be, they have room for whatever movement that is.
They're
without
capped
having
at
to ask.
that, correct. But with the none, there's also a cap, and you will still, it's not automatic that you would get it. Each year, if you wanted to do another increase, if you did get the level none, the board would have to make that motion in closed session, but not necessarily in open session, like if you wanted to change it to a level letter from 2G, for example, or the next one that you were thinking.
I think I have a question that might, well, it might bring clarity to me. Essentially, if a board is successful in moving to none, you're relying solely on the executive officer evaluation position from that point forward in the future, whether it comes to, but within that consideration, while it might be the performance of the EO that's being evaluated, might also include into that criteria for things such as growth, legislative authority, budget authority, all those kind of things.
Correct.
Some of the conversation points are still the same, but this board may not have to ever venture down the exempt position request process if they're successful in getting none, because now it's going to be tied to the executive officer evaluation closed session only.
Not necessarily. The justification will mirror very similar to what you would be doing if it was for the executive officer or for the position. Cal HR, the governor's office, and
Right.
has that approval. And the justification still needs to be approved, like you mentioned. So it can be done in closed session tied to the individual, not so much the position, but we still want to capture any growth, like you mentioned, since the last increase to support whatever the board decides to during closed session versus doing it out in public, doing a letter that may not automatically get you, the individual, an increase. It just will get the position an increase. So in a sense, you would have to almost do two justifications if you went with a letter, one for the executive officer and then one for the position, versus with the none, there's a little bit more flexibility where you can capture everything together.
Both processes.
Correct.
Does anyone have any more questions?
So, with the lettering now, we have to do an evaluation, and if it's a percentage of increase we're requesting, that has to happen for that particular year that we're requesting the increase, right?
I'm not sure if I
The
understand.
steps are not automatic.
The steps are not automatic, correct.
Right.
So once the package is completed, it sounds like you already drafted it, and it gets sent through the chain of command, then Cal HR, who has the final say, will review it, will pull previous requests for this specific board and compare if there's any duplicative information, if there's been growth. If it's pretty much the same information, they may deny it altogether. As Catherine mentioned, they don't like to see us skipping levels. So sometimes they can deny the request altogether. They don't have to provide us with an explanation on the reason why. But for example, to give you some context, if you wanted to, I think right now the difference between his level M and the next level is minimal, less than 5%. So you would be stuck to that increase only. But if you wanted to do a 5%, then that's where the level none kind of plays into play in regards to not having that salary restriction with that level.
Still subject to approval, but
Still subject to approval.
Right. So if I propose a 5%, would that lift the beginning number and the ending number, or it just goes from where the person stays in the band?
Correct. It would just lift the max of the salary to the new percentage. If it was 4% the year approved, that would be the new max of none.
Not over
The minimum would be,
Okay. Then if we go to a non-situation, then it is just what it is, and then it's just a percentage. Let's say a person is on 12,000 a month, and I can propose a 3% or a 5% or an 8%. If it's approved, then that will go to that particular number.
correct, that would be the new max.
That's only once, right? So you could propose a different percentage of the next year?
You may, correct,
You have to assess it, yeah.
correct.
A question about the none category. If a board was successful and their executive officer proved through performance worthy of that merit increase, and it only increases the cap, the bottom of that band still stays the same.
Correct.
If that executive officer were to move on to somewhere else and the board was left with a recruitment process, is there an opportunity at that point as part of the recruitment to reassess the size and scope of the board? Just the recruitment of for new talent?
Correct. The board does have that flexibility to make those efforts.
Tie them to that bottom salary range, right? Should the incumbent leave that seat, it gives them a point for reevaluation to determine what might be appropriate for the next recruitment.
Correct. And if the board was faced with that situation, they would probably want to get that approved first through CalHR. That way, when we advertise for the executive officer position, then we're able to be reflective of the new salary.
Thank you. That's a good question. Are there any other questions about this from the board?
Yeah, I guess both sides of the well, actually, let's say we go with the lettering and request. We have the package ready. We may have to clean it up a little bit with repeat informations and things like that. We submit it to you and simultaneously to the CalHR?
No, so the package would be sent to me, and then we'll work with our director to review it, sign it, and then it'll go to, depending on the timing, the new agency secretary. And then it gets submitted to CalHR and the governor's office at the same time. So I know with previous requests from other boards, HR has offered to review the package before it's officially submitted to our office, just to compare it with previous requests and highlight any duplicative information, or maybe suggest where things can be enhanced or added to, just since we're familiar with some of the packages that come through and some of the things that the control agency is looking for and why they push some of these requests back for additional information. So we can always do that if you want to send us a draft. Once you kind of clean it up and everything, then we can provide you feedback before it's officially signed by the board president.
The non-lettering process is sort of the same.
It's exactly the same, correct.
One last question from me, and then I'll pipe down. But the none category can be determined and be a result of just the evaluation of the executive officer process itself?
So the evaluation and appraisal is part of either package.
Same
Yes.
criteria, same.
Yeah.
rationale.
And of course, but CalHR does want to see if there's been what major accomplishments has been done by the EO. So if that's documented in the evaluation, that's great. But they also want that justification to demonstrate that and highlight anything else. If the executive officer is any DCA initiative or national level entities, then those are the items we want to definitely document in the justification.
Does anyone else on the board have any follow-up questions? Not at this time? Okay. I do want to say before I go to public comment options, I really appreciate the extra hard work the task force has done on this and the staff pulling the information. I know this is not our first EPR, and every single time it's the same amount of work. It's a lot of work. So thank you for your hard work in staying on it and asking the important questions because these are very unique. Every situation is different, I'm sure, as Olivia would know. But at this time, I'll take any public comment. Okay, no public comment on this. I wanted to say, I think that we can probably, there's a decision that needs to be made, but depending on how the board feels, we can determine that at our next meeting, or we can.
Yeah, so I guess, yeah, that prompted a question I was going to ask. Is there a, for this particular EPR, is there a particular timing concerns that we may have, like, whether a decision coming out of the June meetings or the September meetings?
Not necessarily. If there is a new administration that comes into office, then they may change the program itself. We just don't know what that may be, if that even happens. But then that'll be relayed to departments if there's been a change in the process. One option could be to go into closed session today and table the increased discussion to discuss it with the evaluation. I'll defer to legal if that's something they can do, but that's what we've seen in the past.
That's great. So, Ms. President, my recommendation is that we, yeah.
Once the packet reaches you, is there a time frame that you hold on to it before, or depending on if you send it to Cal HR?
We turn it around within 5 business days typically, and then it gets sent to our director and then to our agency. Right now, our current agency is taking about 30 days to review the package, and then it gets sent to the California Department of Human Resources. That also has indicated they would take 30 days for review, so about maybe 60 to some days from start to finish, but they would probably honor the effective date that we would push out 30 days from when we send.
Right. For that reason, I recommend that we have a discussion during the closed session.
Okay, I'm feel comfortable with that. We can include that. Do we have to make a motion for that?
No, that's Michael Kenotes, legal counsel. It's the first time talking today. That is part and parcel of the evaluation, and that is something that should certainly be done in closed session because we're talking about this executive officer. But if there's going to be a proposal to change the level in either way, then that's something we would need to do in open session and put forward.
Well, so let me propose it this way then. The board now have 3 options in the EPR package. And do we have any thoughts in terms of voting on which direction to pursue?
Well, I'm glad that Olivia was here to clarify because initially I was under the impression that none would somewhat be more restrictive, but perhaps it's actually more flexible because it seems like it gives the board an opportunity to make changes every time. Yeah, every year basically, because we are already assessing the EO every year. I don't know how much more I feel like a lot of the work is already done, but I would like to hear from my colleagues on the board.
Yeah, this is not our first time at this rodeo. Um, you're you're correct. A lot of the work is already done. I want to agree with my colleague with Sam that we should be able to make some movement during closed session.
So, legal counsel, is that something that we have to make a motion about if we're making a decision about whether or not we choose to switch the level?
Yes, that's something we could make a motion and do in open session. Because again, setting aside the current executive officer, we're talking about the position itself. So there aren't the same kind of, I know they seem very related, but they're sort of two separate issues. What we talk about in closed session is our esteemed executive officer here. In open session, was where we need to talk about the position level, whether it should be L, or we should attempt to go to the
G?
non-level.
Oh, none, yes.
So do we need, I'm sorry.
I was gonna say, just to clarify, when she was describing what gets connected to the closed session, that's the percentage and all of that stuff that we discussed, right?
That would be
After we get
the evaluation
approved.
and a potential raise for this executive.
So trying to get a letter level change, it's tied again to the position, so that should be done in open session for discussion and public comment, et cetera. So changing it from a letter in closed session would not be appropriate, and I think that's what council is referring to, versus if you're just going into closed session to speak about the performance of the executive officer. In addition to that, you want to provide, for example, a 5% increase that's outside of the salary bands, then you have that discretionary, which would result in that level none tied to the individual and not so much to the position. That would be done in open session.
I want to emphasize something that Michael touched on. And as long as I've been doing this, I've always, been trained and had that common knowledge that these are two completely separate discussions, right? The EPR meaning, is the position commensurate with the regulation of the profession, size, staffing, that kind of thing. In comparison to the executive officer assessment of performance, right? Two completely distinct processes. But it sounds like that during an executive officer assessment, performance review, if that particular incumbent happened to be sitting at a maximum where whatever the board's recommendation was moved them outside of that range, as part of that process, they could then ask for the non-classification, and that whole process would still occur during closed session.
Correct. And I wouldn't ask for the none designation, but versus focusing on like a percentage that they would want to pursue. So currently, if you're at max of the current salary band, if you were at the entry level of the salary band M, the salary increase discussion can still occur during closed session. But because if you're at max and you're trying to change the level, now it's more on the position, going back to that. So if you weren't at max, then those salary discussions could be held with the evaluation as well. And so, yeah.
Appreciate it. So there's no need to do open session if you're not going to choose a letter.
Correct.
Okay, any other questions from the board? Go ahead.
I just need to be clear. So if we change from the requesting L or G and now want to include none, that does not have to be open session?
So let me know if I misspeak, but if you wanted to maybe table that agenda item that's in open session, doing so, I don't know if that would be feasible, and then just going into closed session to have the evaluation discussion, then we can discuss and we'll be present and we can discuss options in regards if you wanted to pursue a salary increase for the executive officer.
I think I got it.
Everyone understand? Any other questions from the board? Okay.
In reality, no motion needed.
Yeah. So we're going to table that. Yeah.
Presented, but no decision.
Unless you're making a motion about a letter. Is there any public comment on this item? Not hearing any, okay. We really appreciate you clarifying and re-clarifying and showing up and supporting us with this process, which is not part of our day jobs. And thank you again for being available.
Of course, thank you for having us.
Okay.
Thank you so much. Well, we will definitely, as a committee, when we have the documents, we'll work with you also. Yeah. Thank you.
All right. So we are moving on to, I think we're moving on to the minutes. What item was that? Can we go over agenda item number 5? Review and discussion of possible action and approval of last meeting's minutes, March 19, 2026. Thank you, Kim. Good afternoon.
Good afternoon. I don't know, would you like me to go page by page or are we going to do it?
Does anyone have an objection to just doing it all together? Is everyone comfortable with that, or did you want to go page by page? Sounds like page.
No,
Okay.
I mean, Kimberly always responds when we send changes, so I'm fine with just
Okay.
doing
And I guess before we start, I wanted to do a small intro on myself. My name is Kimberly Rosakis. I am the board relations liaison for Fiscal Affairs Board of California. And I just manage and I assist all the board members on their training, travel, per diem, anything else that you guys reach out to me, I'm here for. And I also set up and coordinate board meetings, and then just ensure that we meet our board functions and efficiently. I hope I do it efficiently. So
Fantastic job. Thank
yeah.
Planning, logistics,
Yeah.
party planner,
We're gonna no.
travel agent.
Yeah.
Yeah, candy push.
Can I just say you make my life so much easier, and I know I'm the problem child. Okay.
No, we're all the problem child, but I think, Kim, we just appreciate how flexible you are, how generous you are with and just honestly making this easier for us to do while we're doing our day jobs.
Thank you. I thank you all for doing this for us as well. So I appreciate you guys being here.
Thank you.
So is there any, I guess, going back to meeting minutes, is there any other edits that you guys would like?
Does anyone? We already had an opportunity to turn ours in. Okay. All right. So, and any discussion?
When we say that edits were turned in, are those incorporated into the, okay, thank you.
Into the package. Any public comment? Is there a motion for accepting these minutes?
I'll second.
And now? Oh, public comment. Is there any public comment on agenda item 5? Okay. Not hearing any? Go ahead. We'll vote.
Karen Brandon,
Aye.
Dale Armstrong,
Aye.
Tala Kaloff. Tala Kaloff is absent. Tanya McMillian,
Aye.
Sam Q,
Aye.
4-0, motion carried.
Thank you. Appreciate it. All right. We are moving on to agenda item number 6, executive services update, staff introductions. Come on up. or come on down. The Price is Right.
There you go.
All right, I think I'm on now. All right, good afternoon. I'm Sarah Conley, Assistant Executive Officer, and I'm going to kick off the executive unit introductions and give you the plan for the rest of the team. Kim has already introduced herself when she presented the minutes, and Vincent will follow me. Brooke will introduce herself as part of her legislation report, and April will be introduced as part of the outreach report. So with that, I will introduce myself. Again, I'm Sarah Conley, Assistant Executive Officer. I have been with the board for 25 years. I provide direct leadership support to the executive and management teams, as well as assist our executive officer. I also provide indirect leadership support to all the teams, administration, consumer protection, and licensing to facilitate cohesion across the organization, ensuring the board's mission and vision are carried out in all that we do. So it's a pretty cool job, and it's truly a privilege to serve in this role. Thank you for the opportunity to introduce myself today. I'm going to pass it to Vincent.
Hello, everyone. I'm Vincent Azar. My duties involve ADA compliance and IT support, as well as process improvements as it relates to tech enhancements. I also do reporting. And yeah, that's about it.
All right. Well, thank you. Thank you for all you do, both of you.
Simplify that into
I know.
3 categories. It's a little humble. The thing for both of them, I appreciate it's a cool job though. That was a cool quote. I like that. The amount of assistance, and this goes to Mr. Arneson too, that the Executive Services Unit, since its creation, has provided me is undescribable. So I think it's kind of a characteristic of personality that you guys are all being so humble today. I'm like the biggest cheerleader for that team. So thank you.
I agree with Jason. When you guys were talking, I was like, oh, you guys do way more than that. What?
Well, I think it's part of they make it look easy, and it's a lot of work. We know that. We know that. So we really appreciate that. And thank you, both of you. All right. We are at staff introductions, and now.
You have to talk more about yourself.
Yeah, we're going to go through all of 6. So then B is legislative report with Brooke Arneson.
Good afternoon, members. I'm Brooke Arneson, and I serve as the board's legislation and regulation manager within the Executive Services Unit. I oversee the board's legislative and regulatory work. I track bills, prepare analysis, coordinate board positions, and I stay closely connected with DCA, the legislature, and our stakeholder community. On the regulatory side, I guide our rulemaking packages from early concept through final approval, which includes drafting language, coordinating legal and fiscal reviews, preparing board materials, and making sure each package fully meets APA requirements. So with that, I'll go ahead and begin the legislative report. I'll do an update on the 2026 session. I'll walk through the bills that we're tracking, highlight those with a direct impact to PTPC operations, and I'll provide current status updates based on the most recent legislative actions. So we have passed several legislative major deadlines, which I noted in the briefing paper. May 1st marked a key deadline for second-year bills. Measures that did not advance by that date were held and did not continue through the legislative process. As depicted in the graph on that first page of the briefing paper, a total of 112 bills failed to meet this deadline, compared to 188 in 2024 and 191 in 2022. This reflected a significantly lighter volume of bills advancing into the second half of session, which is most likely due to a smaller bill load overall and impact possibly with the state's current fiscal climate, which has prompted authors and committees to kind of narrow their focus to higher priority measures. We have passed the May 15th fiscal deadline and the May 29th House of Origin deadline, meaning all bills that remain active now have moved on to their second house. Your materials included the 2026 legislative calendar, which outlines the remaining legislative milestones, including the July 2nd policy deadline, the August 14th fiscal deadline, and the August 31st end of session deadline, which requires all bills to be voted out of that House. September 30th is the last day for the governor to sign or veto bills, and these dates will drive the pace of the legislative activity throughout the end of the legislative session. So going forward with the legislative summary for updates, we did group those bills into two different categories. The first category is physical therapy board legislation, and then we also went into more of a department-wide legislation. So going into the first bill, AB 2479, physical therapists. AB 2479 proposed a major modernization of the PT Practice Act, which included, but definitely not limited to, authorized PTs to examine, evaluate, and diagnose conditions of the movement system, addressing longstanding limitations tied to the prohibition of diagnosing disease. It removed the 45-day, 12-visit direct access limitation, allowing patients to obtain PT services without referral or prior authorization. It expanded the scope of PT practice, including new definitions, broader intervention authority, and updated terminology. It also increased PTA supervision ratios from 2 to 3, and it also eliminated the electromyography certification program and replaced it with authority to perform evaluation procedures using needle electrodes with physician authorization and PTBC certification. The May 22nd recent amendments made additional definitional and technical updates, including clarifications to the movement system diagnostic language and provisions related to the needle electrode use. We have coordinated closely with DCA legislative and budget staff over the past few months to provide a comprehensive fiscal and bill analysis for AB 2497, including workload assumptions, cost impacts, and implementation considerations. With the status update now, AB 2497 did not pass in the Assembly and is not advancing this session. Okay, going on to the next bill, AB 2774, our sunset bill. So this bill is currently in the Senate BMP committee with a hearing scheduled for this next Monday, June 29th. On June 22nd, the board president submitted an interim support letter, and a copy is included as a handout in front of you. In addition, we have been actively working with the legislative staff in both the Assembly and Senate BMP committees throughout the bill's progression this session. AB 2774 is the board's sunset review bill and would extend PTP's operations until January 1st, 2031. This bill includes administrative and enforcement changes, such as authority to deny reinstatement petitions for individuals required to register under Penal Code 290 or convicted of sexual misconduct. It also updates fee provisions and makes technical changes to align the PT Act with current DCA administrative standards. The bill does not make substantive changes to the scope of practice. Okay. Should I continue on to department-wide legislation?
You have an interim support letter that needs to be ratified. Yeah, we had an opportunity to provide a letter of support. The window happens to close today. So just out of an abundance of caution, board president chose to take an interim support position. But today, now, the rest of the members having that letter in front of you have to agree with that interim support position and make a motion to adopt it wholly by the board.
I'd like to make a motion to support the interim support letter.
I second it.
Does that make sense?
Michael applied. I think it's clear. I don't know.
Okay, is there any public comment? Not hearing any. We can take a vote.
Karen Brandon,
Aye.
Dale Armstrong,
Aye.
Tala Kaloff is absent. Tanya McMillian,
Aye.
Sam Q,
Aye.
4-0 motion carried.
All right, thank you.
Thank you all for that. It is a little bit of house cleaning. It's kind of a little out of the ordinary. We're supporting our own extension into 2031. But I'd also like to acknowledge CPTA and the association for helping us with that same deadline, and the association also giving us a letter of support for 2774. So we made the deadline.
Thank you. You can continue.
Okay, so moving on to the department-wide legislation. First bill on that list is AB 1558, Uniform Emergency Volunteer Health Practitioners Act. AB 1558 is the Uniform Emergency Volunteer Health Practitioners Act bill. It would create a statewide registration system for out-of-state volunteer health practitioners during declared emergencies administered by the Emergency Medical Services Authority. For DCA boards, including PTBC, the bill allows boards to restrict the services volunteers may provide and to impose administrative sanctions to California licensees volunteering out of compliance. This bill was held under submission in the Assembly Appropriations Committee and is not moving forward this session. The next bill is AB 1775 Veterans. This bill was referred to the Senate Appropriations Committee recently, and it expands PTBC's expedited licensure eligibility to include veterans discharged solely due to Executive Order 15183, which restricted military service by transgender individuals. PTBC will need to verify the discharge reason through the DD 214 documentation or other official military records, indicating EO 14183 as the sole basis for separation. In addition, PTBC would be required to track and report these applications in our annual DCA report. The recent amendments on May 18th were more clerical in nature and also clarified cross-agency responsibilities and the requirements for reporting. The next bill is AB 1979, Healthcare Services, Artificial Intelligence. This bill is currently in the Senate and has been re-referred to the Senate Health Committee. The bill was most recently amended earlier this week. AB 1979 establishes statutory guardrails for the use of AI in clinical settings. The bill prohibits health facilities from relying solely on AI outputs to make clinical decisions, and also prohibits AI from directing or supervising unlicensed personnel in functions that require a license. It also authorizes licensing boards, including PTBC, to seek injunctive relief in cases involving unlicensed practice related to AI. So the most recent amendments to 1979 expand and clarified definitions related to clinical decision support systems, the CDCSS, and then expressly confirms that DCA board enforcement authority over licensee use of such systems as well. And that concludes the legislative report. I'm happy to answer any questions members may have on any of the bills.
Thank you so much, Brooke. Are there any questions of the board members on any of the remaining bills? No? Okay. Any public comment? Okay, not hearing any. We're going to continue on our agenda. Okay, rulemaking. See.
It's me again. All right, so CC, or continuing competency, remains the primary regulatory effort on the board's 2026 rulemaking calendar. This proposal would amend CCR sections 1399.90 through 1399.99, and staff continue to advance the work in the initial development phase of the regulatory process. We are currently focused on research and data collection to support 2 regulatory packages. The first package addresses the continuing competency program requirements, including compliance with existing policies and areas where updates might be needed. The second package establishes a per-course fee for approval agencies, which requires a detailed workload and cost analysis. To support the fee package, staff are working closely with DCA on a fee study that outlines PTBC's responsibilities and calculates the time and cost associated with each task. These calculations will form the basis for the proposed fee structure. In parallel, we are gathering workforce and program data to assess how licensees are meeting CC requirements and where regulatory clarification or modernization might be appropriate. This information will guide the development of the draft regulatory language. So at this stage, we still are preparing the materials needed for DCA's legals pre-review, and no draft text is ready for board consideration yet. So once the data analysis and fee study are complete, we will go ahead and finalize proposed language, bring it to the board at a future meeting for discussion and direction.
Thank you.
It's my regulatory update.
Thank you very much. Appreciate that. I did briefly speak with the executive officer a little bit about where we were with this process. And if we're still meeting our guidelines and deadlines, which I guess you can talk about at your executive officer report regarding, yeah.
Or
regarding-
strategic plan goals?
Yeah.
Yeah, absolutely.
But we know this is like a huge undertaking, and that's why a lot of states don't do it. They outsource it or they contract it. But I do appreciate the intention around which we are doing this, and that makes us very proud of knowing that people that go through this process, not only the people that go through the process, but also the those agencies that give continuing education have something, a foundation to utilize, and that takes building it and then reinforcing it and being able to audit it. So thank you for putting in what feels like very tedious time. Does the board have anything else for item number 6C? No? Okay. Any public comment? Item number 6C? Okay. Thank you so much. We're going to move on to communications, but I think that's you. Oh, no. Thank you, Sarah. Communications and education update 6D. And it's not April, it's Sarah.
So Sarah Conley, I'm going to report for April. She's very sorry she couldn't be here today, but I will try to fill in. So, Ms. Beauchamps is the public relations analyst responsible for overseeing all efforts to ensure clear, consistent, and accurate communication with stakeholders and the public. This includes the website, social media, outreach events, and publications and forums. She also assists in the development of key reports, including the Sunset Report, Annual Report, and strategic planning materials. She's very busy. With that, I will provide the reporting quarter's outreach update. There was an overall decrease in traffic and engagement for the website and social media compared to this time last year. This can be attributed to the type and volume of content for each quarter. The prior quarter may have included a higher volume of content pushed out and/or content that was of greater interest to followers. While there was a general social media engagement decrease, the board continues to add followers across social media platforms. The PTPC held 8 outreach workshops for PT and PTA programs and participated in the Burbank High School Career Fair on January 29, 2026 for the second consecutive year. These events, as well as all scheduled events for the year, are included on the outreach calendar included in the materials. And this calendar is updated as events are scheduled. Ms. Beauchamps is excited to share staff is scheduled to attend the 2026 CPTA conference in September in San Jose. Finally, Ms. Beauchamps, as well as PTPC leadership, would like to thank Ebenezer Ariola with DCA Public Affairs for putting together the PTPC's board member recruitment campaign. He did an amazing job, and we appreciate all of his help with this project. And that concludes the report, and I'm happy to take any questions.
Thank you so much. Yeah, I'm very happy that April has been able to do that job fair again for the second year. And I believe also, aren't we a part of a senior fair coming up or something? I thought I saw, yeah, right?
In fact, just this last Saturday, staff attended a senior fair here locally. April was there. Valerie, Kimberly, thank you. She doesn't like it when I say Kimberly. She prefers Kim. And I have a few things to say about that in the EO report, but from everything that I could see via social media and feedback when I got back to the office, it was and that was the second year we've done that particular fair, and it was a success then, and it was a success this time. So
I really appreciate that. I think that the exposure for our board is also really critical for people to understand what to expect in physical therapy and ask the questions that they may not ask if they have to call or send an email. Just, somebody walking by, oh, what is this? And then, oh, I'm getting physical therapy for my knee replacement, and being able to clarify that they do have rights, that they can have those conversations. So I think it goes both ways. It's definitely recruitment, but it's also being visible, right? So I really appreciate that.
Out of it, a lot of people don't even know consumer affairs exists, the board exists, and so really trying to go to where people are to make those connections and push out that information.
Quick question. I don't know, Sarah, if you know, but Jason, when you guys were at Burbank High School, how were you received there? Was it just PTBC or?
No, so at Burbank, I think there were two other boards here from DCA, but that's starting to grow too. So even this last Saturday, there were three other, well, DCA had a table themselves, right? So there's some general outreach there just about the whole idea of professional licensure, but Contractor State Licensing Board, Cemetery and Funeral Bureau, and there was a third board, but we're starting to see more kind of participation across the department for more than just outreach for education and existing licensees, but to stakeholders and then even down into early education. So it's well worth the investment in that while we're there, we're getting kind of like a three-prong approach, right? We're there to talk to future applicants, future students, people interested in becoming a member of that profession, but also consumers of the profession too, right? And then we run across licensees while we're there too. And they see, oh, wow, you know, it's every word counts. Every chance that we get an opportunity to talk to somebody about professional regulation and just educate and provide an explanation of our existence, why we're here, what we do, it's well worth it.
So, Dr. Dre and Kendrick Lamar, they invested all this money in Compton High School, which now is spectacular. It's,
Look, you know
it's an amazing campus. And I happen to know folks.
All right.
Oh,
So let's talk.
fantastic.
That's the other thing is that as the more we do this, and this is this, we had the same experience when it came to the educational programs, right? Once we got going with a few schools, other schools found out about it. And then they wanted that same advantage because while we were there providing outreach, we were also there providing services for the application process, you know, to make it, you know, easier on the cohort for their students to now become future applicants and then licensees. So as we're doing these resource fairs or career fairs, we're getting invitations from others and, you know, local in the region, but still seeing that here's a government agency that's willing to do it. Would you be willing to come do ours also? So there's a measure of resources always to be considered. But again, this is one of those things where I think it's still an investment, right? It's specified in the strategic plan, right? That we wanted to take our current outreach efforts and expand them and try to centralize or focus in on the consumers, the people that we're really here to represent. So this is, they are the hardest target to hit too. I have access to licensees. I've got access to every licensee, right? I've got access to applicants and education programs. But when you start getting into the consumer world, it's a little more difficult. So we're experimenting. We're trying everything we can.
Speaking of, is there a goal or a metric that any other board has used to identify how well they're getting access to the consumers that they protect?
That seems to be a little elusive, right? Because it is a hard metric to try to determine on a performance level how the investment is made, right? We had that same experience even with just the outreach for licensees and for applicants. We saw clear kind of signs, but they weren't measurable, right? We could anecdotally say we saw improvement in the applications timelines. The applications were coming in more complete, and because they were more complete, they were getting licensed quicker. Correlation, maybe not causation, right? But so nothing I could definitely draw a line to and say it's attributed to, but pretty compelling, right? For the consumer side, I don't know. That's going to be a little bit harder one to determine other than while we're there and in the moment and we're talking to people and they're just appreciative of us being there and providing the information. For us, that's rewarding, right? But how do you measure it? I don't know. Still looking for it.
Well, I think it's still incredibly valuable. And like I said, I feel like the visibility is the biggest piece. So
I have one last comment because April's not here. I'm going to take advantage of it, right? She'll watch this back in the recording. So you've all heard her and when she's providing updates. And one of the things that she hates to report is website hits or social media hits that are lower than this time last year, right? Even though it's really hard to kind of discern or attribute why. And before she went out, and we were reviewing these documents, I just said, remember one thing, this time last year, we were pushing out a lot of content that wasn't specific to PT. We were pushing out content for recovery from the California fires, for the governor's office. So all of those hits, all of that activity, all that increase in the algorithm, comparing this year to last year, it's pretty reasonable to think that there'd be actually a significant dip. I expected much more. So to explain her number, right, she can't live up to unreasonable goals, but we'll talk about it when she gets back.
Yeah, and I think just be thankful that we're not in the middle of one of those. Like that was a very specific thing. We could have been another pandemic or another unfortunate California, critical event. All right, thank you so much. Is there any more discussion on item 6D from the board? No, and any public comment for 6D, communication and education update? All right, not hearing any. I think we can go to number 7 and tick off one more of our stakeholders. Consumer and number 7, Consumer and Professional Associations and Intergovernmental Relations Report. If CPTA representative would like to come up and share, that would be great. That is 7B. Thank you, Tamika.
Let's see. Okay, perfect. Thank you. Good afternoon, board members, executive staff. Tamika Island, the Executive Associate of Professional Affairs with the CPTA. Thank you for the opportunity to address you all this afternoon. I'm excited to hear that you will be joining us at our annual conference this year. So thank you for that in San Jose. We'll make sure that you have all of your regular accommodations that are needed. And usually our attendees are quite excited to see you there and to answer their questions and further protect the consumers of California. No updates, actually, surprisingly. I don't have any updates. The only update I would have provided is regarding the legislation that we previously sponsored, which you covered under your legislative report with Ms. Arneson. So I'm happy to answer any questions you may have, if you have any for me.
No, anybody? Not right now.
Okay.
Anything else? Updates? Okay.
Okay.
Appreciate you being here and
Thank you for the opportunity.
Thank you. All right. Is there any other public comment on 7B? Okay, not hearing any. We're going to be postponing 7C to tomorrow. I'm sorry, not 7C, 7A, excuse me, the FSBPT report till tomorrow. We'll probably wrap it into your executive report. Okay, well, we are now moving on to number 10, public comment for items not on the agenda. Is there any public comment for items not on the agenda? Not hearing any. We are now concluded with today's, except for our closed session. So we do have a closed session scheduled now, and I think that is it. All is concluded for today's board meeting. Thank you for participating and attending, and we will see you tomorrow at 9 a.m. here.